Sophia, best girl. Waifu material. 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 Do I look like a cam girl to you? For drugs. Fortress Assault. Hey, what's going on, everybody? It is Artie of Artie's Corporate Fiction. Happy Friday to all of you. Hope that all of y'all are doing well. We got a very, very packed evening for you guys tonight. The first and foremost being something I almost forgot, which is the Blandino sentencing. I only saw a small portion of it live yesterday, and so we're gonna have to see it. I promise we're going to skip ahead, of course, and we're gonna have to skip ahead, of course, and we're going to go right to where it begins and see what happens there. But then we're going to the main event, which is a trial. Van Valiant had just posted it earlier today. Shout out to him. He also sent me the raw footage of this trial of a right to travel nonsense in Wisconsin. So, not to belabor the point, let's get this show on the road. And we are already set up for once. You know, everything seems to be working. Gosh. So, no, we're not doing the bingo just yet. We're going to be doing it the bingo at the trial. So, I mean, I could maybe have done a Blandino bingo, but whatever. So, we're going to get this show on the road.
So, I'm fine, whatever you want. I'm fine hanging out, Your Honor.
We can go forward. I thought that you would have speakers. Is he here? I'm assuming he's here.
Yes, he is here.
He's here.
Oh my God. And this is on for sentencing. Mr. Blandino, do you know of any legal cause or reason why judgment should not be pronounced against you at this time?
Oh God, why would she ask an open-ended question like that? You know he's going to respond.
Yes, I know of many reasons.
Damn it!
The motion disqualified against you in the Riots parallel.
Motion to disqualify, drink.
Enter my appearance, King Blandino. Anyway, I filed a motion to disqualify based on new information, and it's very serious stuff. As you know, I've been investigating.
You're represented by counsel, so
Yeah.
anything that you would have filed is a fugitive
There's motions for
document.
new trial as well. That's
And
pending.
fugitive document. Fugitive document.
But as far as I know, there's a
You're not
placeholder there.
permitted
Yeah,
to
you're-
file You're not permitted to file any pleadings because you are represented by counsel.
That does not mean, Judge, that an attorney, if you force counsel on me, either here, now, what you're doing, or with Mr. Gerstmann, who's a purported appellate counsel, or post-verdict counsel, or post-trial counsel, that he might not adopt and ask to amend that motion for new trial, because as you know, under
Hey,
the law,
Smitty.
Okay.
it must be filed within
All right.
7
Mark.
days.
So, Mr.
You
Bateman,
cannot
is
move
there
forward with
anything that
sentencing.
you want to raise?
No, wait, Debbie, hold on.
If I may, Judge.
Debbie
Yes,
Hartshorn,
if you're
if I may.
housekeeping, ma'am. No.
No.
There are just a few housekeeping matters I did speak to
Thank
the
you.
prosecutor before, just regarding the PSI. I would note Mr. Blandino had asked me to seek the new PSI be issued, but I don't think that's necessary. I think we can clean those up.
Shut up, Alpha.
There's just a couple of, the main issue, Judge, was the credit for time served that was listed in the PSI is, unfortunately, a mistake. It was against Mr. Blandino. They had 200-something days, I believe it was. Yeah, we have it calculated as 134 days credit for time served.
That's correct, Your Honor.
Okay.
Additionally, I believe, I don't know what page it is, they listed Ms. Pendergraft, the man for whom Mr. Blandino is
Shut the fuck up,
caretaker, as
Omega.
his mother. She's obviously not his mother. And the ages of his children are wrong. I believe they're off by a year. They have each of their
Okay.
maybe younger. And then, yes, he did, I believe this one, it's splitting hairs, but I will bring this up to Mr. Blandino, that they listed Mr. Marvin. So I believe it's here in the court today. Listed him as an FBI agent, and
Now, I want to say for the record, I think when I was watching this live on either Mike's channel or on the Nevada Judge's channel, my prediction was 2 to 3 years probation, and that if she was going to highlight his past record, it would be a suspended sentence. She also put in a suspended sentence. I don't know how long, but that was my prediction before everything happened.
I know that he is a city marshal. He did testify that he's deputized and on an FBI task force, so calling him an FBI agent is splitting hairs in my opinion, but at least bringing
Okay,
that
wait,
issue.
say that again, say that again.
It's not FA agent.
I can clarify, Your Honor. Specifically at the page 5 of the PSI, paragraph 6 down, it indicates that on April 29, 2019, an officer with the Federal Bureau of Investigation, later identified as victim 2. So in that portion, it's identifying the detectives that were involved in this investigation as officers of the Federal Bureau of Investigation, which in fact they were. They were both task force officers with the Federal Bureau of Investigation.
That's not
with the
that.
Joint Terrorism Task
I
Force.
object.
And so that's actually very accurate. It doesn't say they're special agents of the FBI, it says they're officers. They were task force officers.
Okay.
So I guess my opinion is splitting hairs. But I believe those are the other matters. So if we could have the record of the minutes reflect those corrections that should be made to this PSI.
Absolutely. So by virtue of the jury verdict returned in this matter, I hereby adjudicate you guilty of count 1, extortion, and count 2, impersonation of an officer. Does the state wish to be heard?
We do, Your Honor.
Go ahead.
Your Honor, we come before you today asking for the defendants to be incarcerated. Right off the bat, that's what I'm going to tell you we're looking for here. I think that the number one thing that sticks out is the defendant's conduct throughout the crimes that he committed in this case, throughout this case, and throughout his history. The defendant is somebody who has zero respect for the law. He's somebody that only believes that the law is here to serve him as he sees fit. Just as he sees the religion and the Word of God that he interprets in the Bible is here to serve him as he sees fit. That's something that I think comes to mind when I look at his sentencing memorandum. There was a retired judge who had wrote a letter in this sentencing memorandum. And, I essentially, two of the things that I noticed weren't in that particular letter that came to mind of my pre-trialing of that individual before trial, as they were noticed by the defendant as a potential witness, was that that individual had indicated that the defendant's religion was whatever he wanted it to be, essentially. And further indicated that in talking with the defendant over all these years and seeing his interest in the law, the question had come up, well, why did you become a lawyer, Mr. Blandino? Well, the response that was reiterated to me by Kim Blandino was, well, then I would have to follow all the rules, and I don't want to do that.
Oh my God, if that was actually what he said.
That's exactly the case.
Wow.
Is Mr. Blandino thinks that he can go around doing whatever he wants, coming into these courts and petitioning inappropriately, making inappropriate appearances, making inappropriate filings, and making inappropriate contact with judges, and he thinks he can do it because he doesn't have to follow the rules. Further, you look at the sentencing memorandum, I believe there's at least 3 letters in here which tend to support the defendant's unauthorized practice of law, helping other individuals left and right, him indicating to these individuals that he can help them, and all 3 of them indicating, yes, I go to Mr. Blandino for legal advice and assistance. That is...
Oh my God, he's relegating to raising his hand, even though he is represented. He's no longer representing himself. Mr. Bateman is his counsel, not standby, but he's raising his hand.
Something that Mr. Blandino has done.
And I think Bateman is right now trying to tell him to put his fucking hand down.
Don't interrupt.
I need a chair and they won't let me sit down. I have a bad leg and I need to sit down.
He can sit down.
Can we sit down?
Sure.
Thank you.
Have a seat.
Thank you very much.
You bet.
Here in this particular case, Your Honor, the defendant repeatedly contacted Michael Federico, pro tem judge for the city of Las Vegas, in an attempt to influence his actions in his capacity as a pro tem judge. In doing so, he caused Mr. Federico and his family immense guilt, to the point where Mr. Federico has since moved out of this jurisdiction. You heard from him at trial. As a result of what was going on, he was carrying a firearm around him. Him and his wife were worried about the path that their children had to take to school. Extremely concerning, and even more so, the fact that the defendant was given opportunity after opportunity to withdraw. He did not have to go down this path. He pressed forward every time that things seemed to take a lull in his mind. And what he did is he ended up upping the ante and ultimately continuing to threaten Mr. Federico and adding threats to what he was indicating he would do. Where he ultimately did make good on some of those threats, which was sending the partners of his firm a package full of everything, all the disparaging comments, everything that he had thus far been sending to Mr. Federico himself. All for what? All because he wanted to have control. He wanted to have control over Mr. Federico, Judge Pro Tem Federico in that capacity, and he wanted to influence the justice system, as we see that he does day after day when he appears in front of this court. It's, as of a couple days ago, he filed this fugitive document. And this has to be, what, the 23rd motion to disqualify? Something that he is doing for the specific purpose of inappropriately influencing the justice system, inappropriately influencing these proceedings, seeking to delay. Just as he walked in here today, seeking to delay this sentencing hearing, it makes clear why he's filed that new, approximately 23rd fugitive document, motion to disqualify. These are actions by the defendant that are not going to stop. These are things that are just part of who he is. And
so, I mean, I'm going to be stating kind of the obvious right now, but Dickerson is trying to establish the fact that this guy, Blandino, does not learn his lesson. He is not remorseful. He is still defiant to the end, and he's refusing. And there is going to be a very, very high likelihood that he's going to continue to engage in the conduct through which he was found guilty of, as aggravating factors towards sentencing. Nancy Marcho asked in the chat, what exactly is a fugitive document? It basically means that it's a document filing that is inappropriate, should not have been filed, because Blandino's represented by counsel. He's not permitted to file his own documents.
we take a look at the theories of punishment. In an American system of justice, we're dealing with really four primary theories of punishment. That being retribution, deterrence, incapacitation, and rehabilitation. Well, what becomes clear is that rehabilitation is the predominant focus for the American justice system at this point in time, given the state that we are in our current history. Rehabilitation is not an option for Mr. Blandino. We take a look back. Mr. Blandino has prior felony conviction from 1994, violation of custody rights, something he was convicted for in a bench trial. And there, too, are so many similarities from 1994, his acts in 1993.
Okay, so he is bringing up his previous actions in here.
And before, to what he is doing now, today, decades later. And I would just reference this for the court for a bit of background, is that the United States Bankruptcy Court out of the District of Nevada had issued an opinion in 2004, a published decision by the Bankruptcy Court. This was a published decision. It's in re Bradshaw. This is.
Hey, guys, part one. Guys, in part one of my series, the Kim Blandino saga, I highlighted this very bankruptcy case. Hell yeah, win for me.
Michael and Nancy Bradshaw, who had filed for bankruptcy. Nancy Bradshaw is defendant Blandino's former common law wife, the mother of his children. She had been placed in dire circumstances as a result of the defendant's actions, and was seeking to have bankruptcy. Mr. Blandino entered that as a creditor, and
I know, Alpha,
ultimately
right?
the federal judge issued
I wish, Mark.
scathing published opinion talking about Mr. Blandino and his history. And I think that the history that is recounted by the federal court is so similar to what we're seeing today that I have to mention it.
Which is why I mentioned it in part one of my series, to establish that what Blandino was doing in this case is a pattern. Well, fucking hell. Dickerson, copying off my notes. Nah, just kidding. Dickerson probably knows far more than I do.
And just for the background, the court there indicated that Nancy Bradshaw as plaintiff, Kim Blandino, were married, in quotes, in 1987. They had two sons, Zach and Andrew, born in 1988 and 1999. And then in 1991, they separated. That's when Nancy had petitioned the state court and was granted primary fiscal custody of both of the children. Although there was an order in effect that was not introduced into evidence, there was no dispute that the boys have legally resided and remained with Nancy since that date. From the time they separated in 1991 until June 6, 1992, Kim and Nancy worked out a periodic visitation schedule. However, June 6, 1992, Kim, without explanation or warning, abducted and kidnapped both boys. Although Kim changed his identity, he was cited in Portland and eventually apprehended with the children in Phoenix, Arizona, on or about January 25, 1993. In all, the disappearance lasted 7.5 months. The children's trauma had been exacerbated by Kim telling them that their mother was dead and that she had spiritual cancer. During that time period, Nancy had no communication with her boys whatsoever. After Mr. Blandino was ultimately convicted and sent to prison, he serves a 6-year prison sentence. He gets out of prison. It was at that time that there's a domestic relations court appointed family therapist to start reintroducing him to his kids again. That therapist, after conducting numerous meetings in the process of reunification, indicated in her report to the court that Mr. Blandino conducts his life by his interpretations of the law of man and God without regard to the expectations of society in which he lives, ultimately leading to issues. And further, no surprise that Nancy was seeking to move out of the jurisdiction. The defendant at that time took further action. I think that is consistent with the behavior that we've seen here. That's when he then filed a Liz pendants on their property.
Liz pendants on the property.
3 days before Nancy's home was to sell, it collapsed. The home sale collapsed because of the Liz pendants that he filed. Something that
Liz pendants on her house.
on her home, yeah, and it was totally without merit.
Is that a question to me?
No, it's
Okay.
not.
No, it's not a question to you.
At trial, Mr. Blandino stated that the lis pendens was to stop the sale because the family court was not fast enough. He indicated here further that to another psychologist that was introduced into the case as far as reunification,
He
that
admitted to filing the lis pendens in bad faith.
he did. He admitted to the court at trial that it was for the purpose of stopping the sale because the family court was not fast enough. That's a quote from the federal judge quoting Mr. Blandino. And then further, he indicated to Dr. Gary Lenkite, who was also appointed by the court, that he referred to the kidnapping of his children as, quote, seeking self-help. Seeking self-help, Your Honor. That's what the defendant's been doing. He's been doing for decades. Inappropriate.
I'm actually surprised he didn't mention the. Maybe he will, but I thought Dickerson was going to mention how he tried to get the entire family division disqualified in the middle of those proceedings back then, kind of like what he's trying to do here.
Illegal self-help. That's what he did in this case. And frankly, it's become clear that he just has no respect for the law. And so that's why I stand here today and tell you that there is no way to rehabilitate Mr. Blandino. Probation is something that is never going to be adequate for Mr. Blandino. It's never going to send a message to him, and all he's going to do is continue with his self-help and continuing to obstruct the process. So what would we even be looking at if we were looking at probation? We'd be looking at a system now that has been changed recently by the Nevada legislature that leads us to a point where Mr. Blandino could get no more than 36 months on probation. And further, the Division of Parole and Probation will be required to submit to this court.
So right now, he'll no more than 3 years probation.
Discharge at 18 months, halfway through. 18 months of probation. That's just inappropriate.
Wait, they said what? He said that what now?
Then 36 months on probation. And further, the Division of Parole and Probation will be required to submit to this court a discharge at 18 months.
So what he's saying is, due to recent legislation, he can only be sentenced for a maximum of 3 years, and then probation would be required to apply for a discharge after 18 months. So a year and a half.
Halfway through. 18 months of probation. That's just inappropriate. The punishments that have been considered and changed by the Nevada legislature just don't work for probation in a case like this. And as a result, we take a look at the other theories. I think that retribution is a theory of punishment, essentially that the punishment must fit the crime. Here in this case, a prison sentence is a punishment that would fit the crime. The prison sentence that I'm going to ask for is a punishment that will fit the crime. And then we further go to deterrence. And under the deterrence theory of punishment, there's two separate theories, right? General deterrence and specific deterrence. The general deterrence theory of punishment being that the punishment that is handed down to Mr. Blandino will deter others from the same criminal actions and the obstructions of our justice system here in Clark County, Nevada. That's something that I think weighs heavily on the fact that there's many people who have watched this trial, who know about this case. I mean, we even have a letter in the defendant's sentencing memorandum from someone who's a fan of Mr. Blandino. The last page, look at his fans. This is a sentence that will generally deter other people from doing the same thing, the same illegal conduct that Mr. Blandino's been doing. And then we look to specific deterrence. That's all we can hope for at this point in time for Mr. Blandino and anything that is going to change in his life, is that prison and the fear of future prison is something that generally deters and specifically deters his bad and criminal behavior. I think that is probably the most clear theory of punishment that needs to be met in this case. What also becomes clear is that the fear of being incarcerated is something that is real. to Mr. Blandino. It's something that does affect his behavior. As we've seen every single time he was looking at potentially being remanded from house arrest, what did he do? He filed frivolous motion to disqualify after motion to disqualify, trying to interrupt these proceedings inappropriately so. What did he do? Right before this sentencing hearing, where he knew the state of Nevada is going to be coming in here and asking for him to be incarcerated, he files another frivolous motion to disqualify.
Not helping his case when he continues to file motions to disqualify in the middle of sentence.
This is something that I think we take into account here as we go forward and we craft a sentence for Mr. Blandino. And what I'm asking for is a sentence that will do just that. Number one, we have 134 days credit for time served. What I'm asking for is first, as to count two, the maximum punishment of 364 days in the Clark County Detention Center. And then as to count one, I'm asking for a consecutive sentence of 1 year minimum to 10 years maximum. The effect of this sentence will be that the defendant will essentially serve maybe 18 months, maybe 12 months before he comes before the parole board. At that point in time, it's going to be incumbent upon the defendant, his counsel at the time, anybody who's coming to speak for him, whether he has other.
So he's asking, Jason, you'll have to look at my Kim Blandino saga series to get the backstory of all this. I can't recount it now. But what Dickerson is asking for is for 364 days for the first count, and then, but he also wants a consecutive sentence, meaning each count in a criminal sentence has their own punishment, right? So if you're caught both stealing as well as fraud, you'll get one sentence for the theft and a separate sentence for the fraud. Now, they can be served consecutive or concurrent. Concurrent means that both punishments will be served at the same time, meaning that if I got sentenced for 6 months for the theft and 6 months for the fraud, then I'll be out in 6 months because I'm serving the time for both charges at the same time, consecutively. Or concurrently. Consecutive means one after the other, meaning that if I get sentenced for 6 months fraud, 6 months theft, I gotta first serve 6 months for that fraud, and then another 6 months for the theft. So a year. That's the difference between concurrent sentences and consecutive sentences.
Fans that are coming in at that time to show the parole board that he is somebody that should be released in the community. But the number one thing that this punishment does is it gives him the maximum amount of punishment on the back end of his sentence. 10 years of punishment hanging over his head. Something that will give him a longer term of supervision than probation ever could. Something that will give him more worry about going to prison and more concern about having to correct his behavior in the future and ensure that he's not introducing himself in a criminal manner into our criminal justice system or into our justice system as a whole during that time period. So that is why I believe that that is the most appropriate sentence here in this case for Mr. Blandino. Again, probation is just simply not an option to adequately punish Mr. Blandino. It doesn't serve any of the prominent theories of punishment in this case, that being, number one, deterrence, both specific and general, as well as retribution. And so, with that, Your Honor, I'm going to ask you to impose that time. I also would mention that the defendant had previously brought up that he was going to seek to have credit for time served or apply for every day that he's been on house arrest. That's just something that is not supported by the law under NRS 176.055, as well as the case of State v. Jackson from 2005. House arrest is just simply not counted toward credit for time served. I would further mention that the Nevada legislature, shortly after they had changed the probation structure, which makes probation inappropriate for the defendant. In this case, they also sought to include house arrest in the credit for time served calculation in AB 160, which did not pass. So with that, Your Honor, I ask you to sentence the defendant as to count 2, 364 days, as to count 1, a consecutive 12 to 120 months.
Anything further?
No, Your Honor.
Okay, Mr. Blandino, do you want to say anything prior to sentencing?
All right. Before he starts, I'm gonna get a refill. So, oh, shit. I need to get ready for this. Everybody, get your drinks while you got them.
Hey everyone.
All right. Everybody got their emotional support kitties? What? What? You were so eager to be here earlier when I was working. Be right on my desk and making fun. What? All right. Here we go.
Am I going to get to speak?
Would you like to say anything?
Yes, I have lots
prior
to say, Judge.
sentencing?
Can I counter what Mr. Dickerson was doing?
That's your opportunity.
I'm allowed to do that? I've got a lot to say. You know, I think I'm just going to run through his points because they're so fresh in your mind, and they get to what I was going to say before I heard such lies from Mr. Dickerson. And they were lies. These things were unfounded, he said, and they were based on hearsay. He brings up Nairobi Bradshaw. No, my religion is not whatever I want it to be. You know, the Lord is my shepherd, I shall not want. The scriptures are very clear on that. We're supposed to eliminate personal and selfish wants. This quote that he said, why I couldn't become a lawyer, is because if I did the bar and I really tried to represent my clients as much as possible, I'd probably be suspended or disbarred.
That's correct, you
Or-
probably would.
I would be
You
because,
conducted yourself the same way.
no, because I would fight zealously and vigorously, and this, then they think he was a great stand by counsel, but he's afraid of you, he's afraid of the district attorney, and you cannot operate out of fear. And I cannot operate out of fear except fear of God. Now, given the opportunity to move forward, as Mr. Dickerson said, this is not true in that I had valid reasons for filing every motion to disqualify. And it doesn't matter, it's 23. There was multiple motions.
23 motions to disqualify. 23.
Disqualified that I had to file before I finally got a judge from another district to hear the case. So you can't calculate those in, because I was successful in getting another judge, albeit just to hear the motion to disqualify Judge Wilson. That's in the record. This isn't fantasy. This isn't some federal court judge that is making things up. And he did make some things up there. The Judge Wilson could have been, Judge Bell easily could have said, no, Judge Wilson, you're going to get this case in chief, rather than just a motion to disqualify. So it took repeated motions to disqualify just to get that. Then you have to start anew. You can't put it as one continuous continuum as though they're all equal. This latest motion to disqualify is on good grounds, and there's good current events happening. You've got your address on somebody else's house sitting up there, and Justice Kavanaugh is threatened to be assassinated.
Oh my God, no!
He's a Supreme Court justice because of the impending Roe versus
Why? Oh God, I could feel Bateman's pain through the video.
Wade case. The person's living in that house, and you had a death threat against you by a defendant. You testified in the case because some maniacal defendant threatened your life, and you testified. That's a matter of public record. So you are a person that, now in the Judge Salas case that I put in the motion to disqualify, that's where a U.S. District Court judge, his son was killed because they got the public records of that judge, and now they're sponsoring federal legislation to eliminate those. But you, when refusing to get these monies collected by the treasurer, you put somebody else's life in jeopardy.
He's referring to the goddamn unclaimed property with the treasury. Why is he bringing that up? Come on. Baby's like, oh, for fuck's sake, just 10 more minutes, man. Just 10 more minutes and I'm free.
Callous and careless disregard of somebody else's safety. All you have to do is go down to the treasurer and claim that money, and then the address gets taken off the website. The sending package to the firm, I got a note there. Anyway, more for primary rehabilitation is not an option.
Respect to Judge Levitt for maintaining a neutral professional face, because I don't think I could have.
By his own his relation of the events, the conviction that happened on the violation of custody rights, there hadn't been any kind of penalty incident or anything in all these years, 20 years, and you properly, in the trial, forbid Mr. Dickerson, because you knew it would be more prejudicial than probative, to introduce that old conviction to the jury. But now he knows he can bring it up here and try to inflame your passions.
Well, that's the problem. In a sentencing, you can bring up prior actions in terms of sentencing. It's just that you can't do it in trial. A judge can fairly say, hey, this is your third time robbing a bank. You know what? So now I'm going to lay down the hammer. That it's perfectly fine, but now you're salty about it.
As somebody who has been threatened by a defendant, an attempted murder, I believe, conviction was garnered in that case, but I'm not sure of that. But the rehabilitation, I've worn this ankle bracelet now on and off for over 3 years. It's been since May, well, I've been incarcerated May 21, got out on the 29th. So on and off since May 29th. This latest thing that you did graciously, I have to admit to that, gave me bail pending this sentencing. You put me on high level, moved me up to the mid-level. But I have a curfew, and I didn't violate any of that. No, there's been no house arrest review. So for him to say there has been no rehabilitation as he jumps from 1994 in some flux DeLorean capacitor, device and jumps.
Did you just say flux DeLorean capacitor?
Forward as though there hasn't been life that has lived between then and now, and good behavior on my part on the house arrest. You'll remember the ankle bracelet was taken off so that I could go visit my PhD son. Both of those boys are a blessing to me, Zachary and Andrew, both in their own way. Low maintenance kids, no drugs, no smoking, no any of that junk. And I can tell you, which the record will not reflect, and it can't, if I wouldn't have taken those kids or not returned them from a visit, I was given them on a visit by Nancy voluntarily. I didn't bring them back. True enough, I did pre-plan that because of the danger those kids are in. Those kids would have been dead.
So,
there was much rejoicing.
So right now he's relitigating his 1990s case and is completely ignoring the present day. He's not doing. What are you doing, man? You need to talk about today.
It was only that life-saving measure. And the other thing he doesn't bring up, which he could find the information, surely. I was offered a plea bargain in that case. I could have taken a misdemeanor plea bargain, credit for time served of 1 day. 1 day I spent on that charge when I was brought back, voluntarily brought myself back to the state. And I turned that down because the statute was bad. And I felt I owed it to other individuals that had subsequently been prosecuted. To my knowledge, I'm the only one that ever got a felony on that charge because I took it to trial. It was vindictively put in because I took it to trial rather than give me the misdemeanor drop, was what the legislature intended when they moved that charge from a misdemeanor up to a felony in 1980 so that the FBI would extradite from another state. They said, well, in the interest of justice. And sure enough, that legislation was changed. The statute as it was then is not as it is now. And I pointed that out to him. As a matter of fact, during the time I was in prison, when the legislature modified
You
it.
want to talk about something that
Yeah.
applies.
Thank God. Okay, the judge is now finally figuring it out and trying to wheel him back in.
In this case, I'd love to hear it.
I did not ever tell the kids their mom was spiritually dead or had
And now he basically ignores.
spiritual cancer. I told other people that later. Never would tell the kids that. As a matter of fact, they didn't even miss their mother during that time, the 8 months that I had them. Exclusive custody. As a matter of fact, that's the other thing too. I went to a licensed attorney, Bob Luke, that signed that letter, was a practicing attorney before I took exclusive custody of the kids. I asked him directly. He's a licensed attorney, worked with John Fadgen. He's a former family court judge now. I asked him, is it a crime if I take exclusive custody? My kids are in grave danger. He said, well, as long as there's no court order, that is not a crime. Now, it may be bad legal advice, but I followed it. I wanted to know whether it was a crime or not.
Oh, for fuck's sake. Okay, I'm gonna skip ahead until he finally starts talking about his current situation and not his old kidnapping case.
And he said that it wasn't. And you have the
What do
speech
you
on that?
think is appropriate?
Huh?
What do you think is appropriate?
Well, obviously, new trial. I filed a motion in that regard.
Well, a new trial is not happening.
Ben did not, he didn't.
What do you think would be an appropriate sentence?
You mean if I had no choice otherwise?
Yeah, if you had no choice otherwise, you can't litigate a new trial here. It's a sentencing hearing. Even if you appropriately filed a motion for a new trial, they're not hearing it today.
A new sentence?
What do you think would be an appropriate sentence?
I'm asking you a condition on that, Judge. I don't think any sentence is appropriate. I think
Okay, so
if
he
you...
doesn't want to answer my questions.
Wait a minute.
Go ahead.
There you go.
How do you want to ask that question again with all the
What
qualifiers?
do you think is an appropriate sentence?
I don't think I committed a crime, Judge.
Okay.
And that says it all. That right there says everything that needs to be said. I don't think I committed a crime.
I was trying to resolve a legal dispute. I took the very discipline that you had and Winker had against you with the Commission on Judicial Discipline, and for those 2 days, I used that as a template to go to Mr. Federico, because he asked me over the phone, and I told him, if I don't get an apology, there's no sense in me preparing a document. I was preparing a
Okay, so
pre-filing.
anything else regarding the sentencing? Because I've heard all the facts and I've heard all the witnesses.
But here's the thing, Judge. You really should have disqualified yourself. I've
Okay.
asked for it to be done,
Anything
non-pro-tunc. No, you want to cut me short again, and I have a lot to say here.
Because you keep talking about stuff that we've already resolved, and we're not gonna redo it. We're not gonna
It
rehash.
has not been resolved. How
So
in the
is there
world?
anything further?
Look,
If not, I'm gonna have Mr. Bateman speak.
look. You should not have been removed in 2015 by the Commission on Judicial
Okay.
Discipline. What you did to Rita Dotson was so wrong, you knew it was wrong, and then you
Okay, so
lied to the
here
Commission
we
on
go.
Judicial Discipline.
He doesn't want to speak anymore.
I'm sorry,
so
this
Mr.
is part of it.
Bateman,
No,
sit down.
I have the right to speak under common
You're
law.
done.
I have the
Oh
right
my
to speak
God.
on the law, Judge.
You're done. Mr. Bateman, do you want to say anything?
Yes, please, Your Honor.
Sit down, Blandino.
Okay, can I ask one more thing?
Sit down.
If you have to take
Mr.
a sentence,
Blandino, sit
I should be
down.
given no more than probation.
Have a seat.
That-
Oh, finally he fucking answers the question. Common law. I mean, we might as well start fucking bingo already. If you got common law on your bingo cards, you can go ahead and click on it.
Does that answer your question?
Yes.
This woman here, I take care of her. Michael,
I understand. I know.
Now he's finally actually answering the question. You know, if he actually started out by saying, "Hey, I have an elderly woman that I take care of," that might actually help you. But no, you refuse to do that. You continue to be completely disrespectful, disruptive, ignoring answering the basics of questions, and also being completely hostile to the judge. Oh my
I need
God.
to take care of her.
I know that.
I will do all the
I
public
see you're
service I
here
did.
today. I know that.
Yeah, I've got the medical studies that Ben's doing. I got a 5-year study that can help a lot of people. I'll donate the money to
Jazz is correct. He did also say for the record. If you have for the record on your bingo cards, you can click it now.
charity. I do not want the
So
money.
you do have the ability to talk about sentencing when directed to.
Okay.
Okay.
Can I talk
Mr.
about it then?
Bateman,
Can I
go
talk
ahead.
about it then?
Mr. Bateman, now I want
Can
to
I
hear from
elaborate
you.
on that?
Thank you, Your Honor.
I want to hear from Mr. Bateman.
Yes. Thank you, Judge. As for sentencing, you've heard from the state, you've heard from the defendant, and I don't know if we're going to hear from Mr. Federico, he was noticed, but, and I think what's appropriate here, I think to bear in mind, is one of the admonishments I gave the jurors is to, I think it's still apropos today, is to sort of separate our personal feelings about Mr. Blandino and not let them cloud sort of our ability to see objective reality. I mean, everyone that's been involved in this case has
Hey, Debbie.
suffered indignities, personal insults from Mr. Blandino being a part of this case. And so it's, I think, appropriate to step back and sort of dispassionately look at what we have here. And I think one of the points that Mr. Blandino made that I think is valid here today is that there's a significant passage of time that the issues that the state brought up of his prior case in 1994 is really not relevant to what we have here today. There's been a significant passage of time with him not doing anything, saying that he has no respect for the law, and if that were true, he'd have a long string of arrests, of convictions, of other run-ins with the law. He's been on the electronic monitoring program, Judge, yes, off and on, for 3 years without any incidents. He can submit and obey authority. He can. He's shown that. I think the...
Now, everybody, please, please, please do not give Bateman anything. He is a defense attorney. He is doing his job, and he's doing his best.
Additionally, you know, he hasn't been to Mr. Federico's house. He hasn't been to his office since April 25th, 2019, the last time he dropped off a letter. I know Mr. Federico testified that he thought he saw him and other things, and I understand. Maybe it affected him, but, you know, his subjective beliefs aren't, like I said, we need to look at the objective reality. Mr. Blandino never was on an ankle monitor, never went anywhere near Mr. Federico or his family or anyone or anything, anyone in his family or anything of that in that nature. He hasn't violated the stay away order also from who was it, Judge Nordstrom. He hasn't gone and done anything of that matter. And in fact, if you recall during the testimony of the trial, detectives went to his house. They searched his house, pursuant to the search warrant, and they didn't find anything that was threatening at all, nothing that would raise a red flag. And that's because he's not a physical threat to anyone. He is not. And so I don't think it's appropriate to send someone of his age to prison based on that he's not really a physical threat. And he's, let's be, and I think anything that that the state brought up, I think certainly can be cured with conditions of probation. Judge, he has, and I think it's right what Mr. Dickerson said, that the threat of going to prison or incarceration motivates him. That's why he didn't violate his house arrest. That's why he was perfectly compliant, because he knows what the consequence of that would be. I think that same similar belief will be in effect if Your Honor should grant him probation. And I think that, okay. And to say that, to say that he has zero respect for the law is not proper. What he cited were examples from more than 2 decades ago, almost 30 years ago. But what's more recent is that he hasn't had any incidents on house arrest, no contact, and I think the things are overblown. The threat, I think we're giving him maybe too much credit. On all the legal filings can be cured really by any condition of probation. Additionally, we have counsel who will be representing him on appellate matters. And quite frankly, I mean, it's ironic, the Supreme Court denied the one filing he made, citing Blandino v. State, his prior conviction in a twist of irony. So I think if you make it a condition of probation that any fugitive documents filed while on his pursuing his appeal would be considered a violation of his probation. He'll have counsel who is very experienced and very capable of handling that. And so any abusive process, quite frankly, can be curtailed, can be cured with conditions of probation. Additionally, yes, he does care for Ms. Pendergraft. I think that is perhaps one of the redeeming qualities he has that I think helps keep him grounded, that keeps him centered, that keeps him focused. And I know he does a lot. He does a lot of work on her behalf. And he did that. He knew the family prior to her when she was with her. I believe they were neighbors. Knew her family, knew her husband, and when he passed away, and then her son passed away. He made a promise that he would take care of her, and he has, and he's done that, I believe, for the last 13 years or so. Okay. So I'm sorry, he didn't know her husband before he passed away. But he didn't know her son was, they were neighbors, and made the vow that when her son passed away, that he would take care of her, and he's done that. And I think that's another reason why probation would be appropriate, because again, that fear of incarceration, he knows the effect incarceration would have on Ms. Pendergraft. I don't think he would risk it, quite frankly. I think, not to insult him, I don't think he's a threat or someone who we should see as a threat. I think it's a little bit more someone deserving of pity. Quite frankly, his and all of these filings that he's done, the 2 things he's gotten were letters of caution.
Bateman can't help but laugh at this point. Laugh to hide the pain.
Issued to Judge Baird and Judge Hernan. You have to understand the Nevada Commission on Judicial Discipline to even understand their process and their machinations to really even understand the letters. And we heard, because no one else had ever given him the time of day. No one, on all his previous filings, he's doing this for years, at that time when he was staying out of trouble, no one ignored it, and he went away. There was nothing. We're here because, Mr. Federico did something, and...
What did Mr. Federico do?
Pardon? Because Mr. Federico contacted the police and started that ball rolling in front of me. And to say that, the state that, they contacted Mr. Federico. Well, Mr. Federico asked for that. When he called him and said, what do you want? What are you proposing? give it to me in writing. Genuine for the state to say, oh, well, he kept harassing Mr. Federico, sending them things that they were being asked for, and sort of laying that trap. Again, that's what's ultimate. It was woefully unprofessional. I honestly, I don't know that Mr. Federico's job, and I can't say that, but I would speculate, Judge, that the partners knew that this was not someone to be taken seriously. I don't believe that his job was seriously in jeopardy. Someone of his reputation and renown here in the legal community with his partners and having this letter, I don't think was something that, again, was taken seriously. I think we give him too much credit for his ability to cause havoc. I think he is deserving of probation, Judge. I think someone of his age, of his temperament, would be a target in prison, and is not, is not appropriate. I mean, I think, look, the law is what the law is. The state legislature passed these new laws as to probation, and we ought to respect the law. That's a thing that came from this trial, and so I think, despite what they are, they are what they are, and I think the fear of incarceration for Mr. Blandino is real. I think that he should be given probation. I don't necessarily disagree with a longer sentence on the back end, so that he would expire on parole, and I guess have a long time to expire on.
Hey, Wazoo.
If you're
what's going on, man?
But I think you'll see, Judge, that if given probation with the threat of going to prison at his age, I think he'll comply. He'll be compliant. I think the concerns about filing or doing other things, I think that's really the main, threat, as it were, would be filing things that are not germane. He has been deemed a vexatious litigant, so in that regard, that's cured, as it were. He has to get permission, I'm not exactly sure how it works, permission from the chief judge, I believe, in order to file. And so I think, and then
He really
anything on
didn't
his...
do that with these last filings.
Pardon?
He didn't do that with these.
I understand.
There's about 3 different things that were.
And I understand, and I think that's why I suggested making it a condition of his probation that anything that's not on his appeal, since he's represented by counsel, that any fugitive documents that are filed would be considered a violation of his probation. I think that can be, would cure that concern. That obviously wasn't, I don't know, it was discussed at his release. So I think, Judge, he obviously, he doesn't feel that he did anything wrong. I understand that. And long term at the end, so he doesn't, to fix the law for him to expire is appropriate, and I would submit on that.
In accordance with the law of the state of Nevada, this court does now sentence you as follows. In addition to the administrative assessment, the DNA fee, and the collection fee, you'll be required to submit to genetic marker testing. As to count 1, the court's going to sentence you to 12 to 120 months. Count 2, 364 days in the Clark County marker.
Wait, I think I almost missed it. Hold on.
Sentence you
To fix the law for him to expire is appropriate, and I would submit on that.
in accordance with the law of the state of Nevada, this court does now sentence you as follows.
Holy shit. So basically, she doesn't even go through her own motions. She goes right into the sentencing, which means that she already had a sentence in mind and off, immediately.
In addition to the administrative assessment, the DNA fee, and the collection fee, you'll be required to submit to genetic marker testing. As to count 1, the court's going to sentence you to 12 to 120 months. Count 2, 364 days in the Clark County Detention Center, concurrent to count 1. It'll be suspended. You'll be placed on probation.
So basically, she almost gave Dickerson what he wanted. 364 days and 1 to 12 months, 1 to 10 years, but suspended.
To exceed 3 years with the following special conditions. You'll be subject to intensive supervision pursuant to NRS 1768.440 as deemed appropriate by parole and probation. You're to have no contact with the victims in this matter.
The 3 months.
There was much rejoicing.
Oh, not 3 months. I mean, sorry. Oh, did she say 3 years too?
Either directly or indirectly. You are not to file any documents unless they're consistent with the vexation litigant order. You're not to file any fugitive documents. So when you're represented by counsel, you're not permitted to file documents on your own. Your attorney is required to file those documents, so you'll be required to follow all court orders, undergo a mental health evaluation, and any counseling as deemed appropriate, and you'll be required to comply with all general conditions of parole.
Not to exceed 3 years. So
And there was much rejoicing.
I was almost accurate. I thought it was a suspended sentence and up to 2 to 3 years probation. So I think I was somewhat accurate.
Probation. Were there any other conditions that the state was concerned about?
I don't know what genetic marker testing is, because it sounds like she distinguished that from DNA. So I actually don't know what genetic marker testing is.
We have concerns. In looking at the current conditions, the no contact with the victim, directly or indirectly.
Or at least it sounded like she distinguished the two.
Indirectly contact Mr. Federico, as he has filed a pro per civil suit against Mr. Federico in the federal court for
what?
this, for going to the police in this case, essentially.
That was filed in July
It's
of this last year.
Again, something that's totally appropriate, and he's been using Mr. Federico's counsel to try to talk to Mr. Federico, to relay messages, relaying to him some proposed offers of settlements and whatnot. Again, it's just another action by Mr. Blandino that's totally inappropriate. So I don't know how the court wants to handle that.
They have no contact with Mr. Federico at all. I mean, obviously, if they're in other litigation, he can have contact with his attorney only. He's not to have any contact with Mr. Federico.
So I think she's highlighting the conditions of his probation, which, yeah, we'll see if he adheres to those.
Anything else?
Further, we would ask that the term be fixed for 2 years. Because I just think that we're in a position right now where he's going to be up for discharge in 18 months. It's just going to be inadequate for any type of supervision over him. Further, we
I think a fixed term would be appropriate. I can set for a fixed term. I believe they will still submit,
yes.
and so I'll make that determination at that time.
In addition to that, we would ask for a full financial disclosure of the defendant. I think that what's been called into question as far as his finances is his current living situation. He's relied heavily upon his caretaking of Ms. Pendergraft here in this case throughout to avoid any sort of incarceration or a prison sentence. The state does have concerns about that situation overall. He's indicated that he's being paid $500 a month by Ms. Pendergraft for his caretaking services, but obviously that's disclosed there. We just asked for a continued financial disclosure in this case.
Okay. To his probation officer?
Please.
Okay. And that you make full financial disclosures to your probation officer as deemed appropriate.
And then does I just want to make sure whether the general conditions have it or not, but I think it should be specifically stated as a
Put your dumbass hand down.
full electronic search clause.
Oh, sure. Yeah, that's
I'm
part of
sorry, I
the,
missed that part, full
yeah,
electronic
it's
license.
one of the general conditions of parole and probation is that you'll be subject to search. Your person, where you live, your electronics.
There you go.
And further, as with the conditions that have already been placed on Mr. Blandino as far as filing with the courts, we would ask that we continue with the same restrictions, time and place restrictions for Mr. Blandino for the courthouse. This courthouse, as well as the municipal court, that he not be permitted to enter these facilities unless he actually has a case on calendar.
and that's appropriate. Court's going to order that you not have any contact with the courts or go in the courts or the courtroom unless you're there on official business.
I can call
for
them up on the
yourself.
phone though, right?
No,
No.
unless you have official business.
No, that's what I'm saying. If I call up to initiate a case,
If you have
or to get
official
documents,
business,
or to get certified documents,
that would be official business.
okay?
So if you have
Well-
official business that's outside a case your attorney is representing you on.
I got one of
but you
those
wouldn't be able
remands
to do
because
it on
Leah
this
Williams said
case.
official business,
Okay.
Judge, and
All right, so he
it was
is
in
not,
dispute.
you know what, if I were you, if you have a question, I'd ask your lawyer, because if you come back here on a revocation hearing, it's not gonna be good for you.
And with that same, as far as his official business comments, another concern that's raised throughout his history in this courthouse, as well as within his sentencing memorandum, is that it seems to you and other people view him as having official business in their legal proceedings. We would like that the court make it very
That would
clear.
be illegal, because he's not a lawyer, he cannot represent other people, that would be practicing law.
But I can
without
file as an
license.
intervener in the case.
And him
Oh my God! Stop. Sorry, I'm yelling at my audience. I'm sorry, but for God's sake, stop trying to weasel your way out of these things. He keeps trying to weasel his way into a loophole every single fucking time.
seeking any sort of investigation or contacting courts on behalf of anybody else be absolutely prohibited.
That would be correct, because that would not be on his behalf. So, at this time, I know you want to appeal it, and the Supreme Court has indicated that you would not be able to represent yourself on appeal. So,
The appeal's
this
already
time-
pending, Judge. It's, the
Okay.
briefing's just been
Okay,
suspended.
they're not gonna let you represent yourself,
84433.
okay? Just so you know.
We'll see.
So, good luck, because they're not gonna let you represent yourself. But if they do,
That doesn't mean
Have
they
at
won't
it.
let me file supplemental briefs as in
Okay.
Domenico versus
all
State.
right, then that's up to them,
I see.
that's why
And
they're
they
the
say
Supreme
these aren't
Court.
people.
So, Mr.
So
Bateman,
we are concluded then with the
We are.
sentencing and the conditions, then I would move to withdraw at this time.
okay, so Mr. Bateman can withdraw at this point, and the notice of appeal has been filed, correct?
Yes, 84433 is the case number.
Okay, I just wanted to make sure,
Well, he does have appellate counsel, I believe, will,
Purported appellate counsel.
uh-huh. Yeah.
through Mr. Christensen's office, I believe, will be handling all the matters of the appeal.
And so
including the
counsel will be
notice.
appointed now. I would just make sure you check to make sure that notice of appeal has been filed and that it's all good. And then the bond will be exonerated. He'll be released from house arrest. And you're to report to probation within 24 hours of leaving court today.
And just to be clear, new counsel is appointed in this case as well. For all
That's
future
correct.
cases. Thank you.
And I need to issue an objection to that. I want to represent myself on appeal.
I know, that's what I thought I tried to make
Of course he wants to represent himself on the
clear.
I had to make
The
an
Supreme
objection. to
Court's
that.
not gonna let you.
Yeah.
However, if they decide,
We'll see.
then that's
I
great.
just talked to them last month.
That is
And I told them they
fantastic.
can't do that.
I do not believe, if you represent yourself, but if they decide otherwise, that's
They can in
fine.
every other appeal
So
but
that's
criminal
why I
appeal.
just wanna make sure your appellate rights are protected
Uh-huh.
unless and until they make that decision.
All right, so are you confirming counsel today, Joe
I am
Thurston?
appointing counsel today.
Okay, over my objection now.
Over your objection.
Yes.
Thank you.
And so the motion to... Go ahead.
All right,
Thank you.
Thank you.
Thanks, Judge.
thank you.
I hope you're safe.
Excuse me?
I said, I hope you're safe at all times.
Grab your things and exit the courtroom before you get yourself in trouble.
Thank you.
Counsel?
It's a normal thing they say. Be safe.
Uh-huh, thank you. Sorry about that.
Let me see, I helped before. Are you going to give me the...
State versus Richard Babb, C-3563.
And it's over. It's over. Ben Bateman just fucking running. Oh, God, that was a painful one. Oh my God, Mandy. Oh, let's go through the super chats. And I'm gonna need another refill and get this, and we'll get ourselves ready for this trial.
Okay.
think we're starting with Ed.
Okay, it's loading. Sorry, stream element.
No worries. I can go for it then. Then the next time. You got it. Ed2276 sent a $10 super chat. How did I know Blandino would say he has lots to say? Because it's Kim Blandino. Phoenix, $5. Shout out to the female officer rocking the mohawk. I did notice that too. I'm glad I wasn't the only one. Stephen Alley, $2. Leave it to a lawyer to defend a lawyer. Vomit emoji, JK.
I apologize. It's like
it's okay, no worries. Kristen Rapp, $5. Blandino's defense attorney has mastered the art of the compliment sandwich. Very good. And that's it. All right, we got this. Yeah, Debbie, we are just getting started. We got a trial in our midst, Debbie. So this is from Van Balion's latest video that he posted today. He was kind enough to send me the original video, and I was able to put it through an audio filter so that you guys can actually hear the judge a lot better than the original video. So let's get that show on the road.
Wonder rebel investigations, but
oh, and we're also going to bring up the bingo. Now, did I have anything in there? It was common law and for the record. For the record and common law. There you go. All right. And also, we're going to skip through the 10 minutes into the actual trial itself. It is a right to travel in Wisconsin. So just to give yourselves a heads up.
yes, sir.
This then is the trial, and
Wait, what the? Oh, no, I'm sorry. This is the wrong video. I'll let you guys know here's the difference between that and this. You could barely hear the judge then, but now listen to it. Now listen to it.
city and then cross-examine.
Shout out to oh my god, his name's drawing a blank. Shout out to Road Pirate Films for giving me the audio filter to fix the video, the audio quality.
Then when you have rested your case, the city could offer rebuttal testimony, and you would have the right to do the same. I will then give each party a chance to summarize their view of the case before I make my decision. If you have any exhibits that you want to use in the trial, you must first show them to the other party. Because this is not a criminal case.
I do have one question about that last part.
Yes, sir.
What if it is all case law that an attorney should know already?
Well,
that is literally used on a daily basis by the courts.
Liar.
certainly even after the trial, if you request the opportunity to submit case law to me in favor of your decision in this case, I would certainly accept that.
So I can't at least read out the part of the case law that pertains to this case and cite that case law?
How long this is going to take?
Oh, I'm not trying to read out a whole lot. It's just maybe 2 excerpts with the case law.
I'll let you make that as part of your closing argument.
Yes, I fully understand that. I'm reasonable.
Okay.
I'm not trying to take up all day.
Because this is not a criminal case, you should understand that the burden of proof is not beyond a reasonable doubt, but clear, satisfactory, and convincing evidence.
Okay, so that's actually a standard I'm not accustomed to, which he said it's not because this is civil traffic or civil case in traffic court. He said that it's not a beyond the reasonable doubt standard, which is the criminal standard, but clear. He said clear and satisfactory evidence. Usually when it's civil, it's preponderance, but by the preponderance of evidence, which if you want to quantify it in numbers, think of it as 50% plus 1.
criminal case, you should understand that the burden of proof is not beyond a reasonable doubt, but clear, satisfactory, and convincing evidence.
Clear, satisfactory, and convincing evidence.
Further, as much as there's no right against self-incrimination in a civil trial such as this, you may be...
But clear and convincing, okay, so it's actually higher than preponderance. My understanding and my knowledge, clear and convincing evidence is like that midpoint between preponderance and reasonable, beyond reasonable doubt. It's like more like the 75% standard, you know?
called as a witness by the city.
Like 2/3.
Yes.
Do you have any questions about
3/4.
anything so far?
Nope.
All right. Move to the counsel if you'd like to proceed.
Thank you, Judge. Judge, just
Oh, and
Oh,
I hesitated, or I forgot to address the first motion to dismiss. With no objection from the defendant, I will dismiss that charge.
Thank you.
So, yeah, guys, I apologize if the audio still isn't great, but I promise you that this is worlds better than the original audio. You could not hear the judge's voice in the original video. So, I promise you, the original's much worse. Go check out Van Ballian's video. So, what was I gonna say? Before they started, the prosecuting attorney said that she was going to drop the charges on insurance. I don't know why, but they were dismissing the charge on insurance. So he's there for no license, driving a moped without a license.
Judge, I have for both Mr. Kern and you, if this is a copy, I've just copied the statute that is listed, thank you, that's listed on the citation, as well as another statute, because I believe that the citation should be amended, which is allowable by statute. And this amendment would be in Mr. Kern's best interest. The Wisconsin statute, section 343.053A, says no person may operate a motor vehicle, which is not a commercial motor vehicle, upon a highway in the state, whereas subsection 3C is more appropriate here. It says no person may operate a moped or motor bicycle unless a person possesses a valid operator's license, or two forms are listed here of a special restricted operator's license. So, if there's no objections from Mr. Kieran, I would move to amend the citation to 3C. And I would note two benefits to the defendant here in that 3A, I believe, is punishable by
Yes, motorized bicycle.
200, forfeiture of 200, and this one is only a forfeiture of 100. Also, a conviction under 3A, one conviction is civil, but if he has a second offense within 3 years, it's charged criminally. Whereas that I do not believe that is the case under 3C. At least under the penalty section, 343.055C, for that violation, it does not state such. So those two are benefits to Mr. Kern to proceed under 3C as opposed to 3A.
You understand the difference?
I do, kinda.
Kinda?
The problem that I have with that is, one, I know one of the statutes that they're citing, I've looked it up because it was given to me when I was denied my pretrial.
Oh, yeah?
And I looked it up. The one for the motor vehicle, which is not commercial motor vehicle, is valid. The other one, when I looked it up, it said that that one was repealed, which my understanding...
I don't know. So I don't know where the hell he's getting this idea that whatever part of the law he thinks was repealed was repealed. I haven't seen any of that, but I can cite to you the exact statute in Wisconsin that we're looking at, which is 343 guilty spark .05 3 4. Oh my God. I can't count. I just missed it. Kills me off. There we go. 3C. No person may operate a moped or motor bicycle unless the person possesses a valid driver's license or a special restricted operator's license issued under 343.135 or restricted license under section 343.08. License under this paragraph does not authorize the operation of moped or motorcycle if the license is revoked, suspended, canceled, or expired. So he's required to have a license.
Means that's no longer valid law. As well as the fact that if you look at the very bottom, my bike falls under these parameters. So my bike is a low-speed motor-assisted bicycle, which is federally regulated as a bicycle.
Okay, so when I first heard this, that's where I thought, okay, this is the gimmick that this is where this guy's trying to be cute. He thinks that because his motorized bicycle or motor bicycle falls under a federal definition, he doesn't have to have a license, even though it squarely matches the definition of a motor bicycle under Wisconsin law. That's not how that works.
Not a moped or a motor bicycle.
Just because it might fit the definition of under a federal law doesn't mean it can't fall under the definition of a state law. That's what I'm trying to get. It could be both. It could qualify under both.
On top of that,
what is wrong with people?
We'll get the whole case law out the way right away. Every citizen, it's been ruled tons of times over the decades, the right to travel on the roadway is not a mere privilege that can be regulated. It is a fundamental right under life, liberty, and the pursuit of happiness, and cannot be regulated by the government unless it interferes with somebody else's rights. And requiring somebody to have a license, registration, insurance, even though they're operating safely, is honestly against all of these case laws.
Wrong.
Which include Miranda versus Arizona, Chicago Coach versus Chicago, among many others, and that's all I'm quoting on those.
Could I get back to the point then?
Yes.
Do you have any objection to the amendment, which appears to be in your favor, to section 3C as opposed to 3A of 34305?
You can amend it, but even by that and her own definition here, I don't fall under it.
Okay. Right.
So I have no problem with you amending it.
So it doesn't matter. The burden of proof is on the prosecution to make sure that your whatever you were on, whatever vehicle, whatever the fuck you call it, matches the definition of a motor bicycle. And as a matter of fact, I have that right here, ladies and gentlemen. Let me just pull that up for you guys right now. Motor bicycle means a bicycle to which a power unit that is not an integral part of the vehicle has been added to permit the vehicle to travel at a speed of not more than 30 miles an hour with a 150-pound rider on a dry, level, hard surface with no wind and having a seat for an operator. Motor bicycle does not include an electric bicycle or moped, just in case. Moped means any of the following motor vehicles capable of speeds of not more than 30 miles an hour with a 150-pound rider on a dry, level, hard surface with no wind, excluding a tractor, power source as an integral part of the vehicle, and a seat for the operator. A bicycle-type vehicle with fully operative pedals for propulsion by human power and an engine certified by manufacturer at not more than 130 cubic centimeters or an equivalent power unit. A motorcycle with an automatic transmission and an engine certified by the manufacturer of not more than 50 cubic centimeters or an equivalent power unit.
It's just, even by her own paperwork, my bike doesn't fall under it.
Based upon those statements, then.
Now, ladies and gentlemen, will he actually provide the evidence that his whatever that he was on does not match those definitions? I highly doubt it.
What will allow the city to amend that charge?
Thank you, Judge. At this time, I'm going to call Officer Philip Davis as the city's first witness, please.
Good afternoon. Please raise your right hand. And do you solemnly swear that the testimony you are about to give in this proceeding shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir.
Officer, would you please state your name for the record?
Officer Phil Davis, badge number 9746.
Thank you. And how are you employed?
I work for the City of Racine Police Department as a patrol officer.
And how long have you been with the Racine Police Department?
Over 2.5 years.
And throughout that 2.5-year tenure, have you always been a patrol officer?
Yes, ma'am.
And were you on duty as a patrol officer on Sunday, August 15, 2021 at approximately 9:56 p.m.?
Yes, ma'am.
And on that date and at that time, were you dispatched on a call?
Yes, ma'am.
And where were you dispatched to?
I believe Wright Avenue in Thurston.
And why were you dispatched there?
A motor vehicle accident.
And did you respond to that location?
Yes, ma'am.
Is that location within the city of Racine, state of Wisconsin?
Yes, ma'am.
And when you arrived at the scene, can you please briefly describe what you observed?
I saw other officers on scene, a motorized bike, and a man on the current getting loaded into an ambulance.
Okay. And you said that you saw a motorized bike. What can you describe what the motorized bike looked like?
It was a pedal bike with a motor on it.
And when you say a motor, how does that motor operate or what powers the motor?
So now, she's saying, she's now establishing what was he riding, and again, this is witness testimony, which is evidence. Is he going to bring anything up to try and contradict the officer's testimony as to his description of what he's riding? No, he's not. Of course not. You wouldn't be watching this if he was going to do that.
And when you say a bicycle, you mean a pedal bicycle, basically?
Yes, ma'am.
Okay. And the motor's attached to it, and that's what propels the bicycle?
Yes, ma'am.
And did it have a seat for the operator to sit on?
Yes, ma'am.
And if you had to venture a guess, approximately how fast would that bike go?
I had to venture a guess, probably under 30 miles an hour.
Okay. And have you ever seen other motorized bicycles operating around the city?
Yes, ma'am.
Okay. And in your experience seeing those other motorized bicycles, roughly, are they going under 30 miles per hour?
Yes, ma'am.
Okay. Do you have any other reason to believe that this particular motorized bicycle would operate over 30 miles per hour?
Not that I'm aware of, no.
And who was on the gurney?
Richard Kearns.
And did you identify Mr. Kearns?
Yes, ma'am. I asked him who he was. He gave me his name and spelled it for me.
Okay. And do you see Mr. Kearns in this courtroom?
Yes, ma'am.
And would you please point to him and describe one article of his clothing?
The gentleman here with the grayish green shirt on.
Thank you, Judge. May the record reflect that Officer Davis has pointed to the defendant.
It was so reflected.
Thank you. And Officer Davis, did you learn what happened at the scene before your arrival?
Before my arrival, it just stated that a motorized bike hit a vehicle. When I got on scene, Mr. Kearns explained to me what happened.
Okay. And How did he explain it to you? What did he say happened?
He stated he was traveling eastbound on Wright Avenue. He saw a vehicle pulling out. The vehicle hesitated. He then sped up, and then the vehicle pulled all the way out. He hit the vehicle as it was pulling out.
And while you were on duty on this particular call, were you equipped with your body camera?
Yes, ma'am.
And was it operating throughout your interactions with Mr. Kern?
Yes, ma'am.
And did you preserve the footage that was on that body cam from that incident?
Yes, ma'am.
And at any point before today, did you watch the footage from your body cam?
Yes, ma'am.
And did that footage accurately reflect the interactions you had with Mr. Kern on August 15th that evening?
Yes, ma'am.
And did you issue any citations to Mr. Kern that stemmed from the August 15th incident?
Yes, I did issue citations at a later date.
Okay. And what were the citations for?
Operating the vehicle without valid license and operating the vehicle without insurance.
Okay. And as you know, we have moved to dismiss the insurance.
So he just mentioned that he cited that he cited it for no license and no insurance, but as the prosecutor said, that they dismissed the no insurance charge.
I'm only going to ask you about the operator citation, but did Mr. Kern have a valid driver's license on August 15th, 2021?
No, ma'am.
And how do you know that?
I asked him if he had one. He stated he did not.
And I'm going to... Mr. Kern, I'm going to give you a copy of this. This is what I'm going to hand to the officer, okay?
Okay.
Officer Davis, Officer Hill's going to show you, Officer Davis, sorry, I should have told you that, that's my fault. Officer Davis, I'm going to show you this document, and I'm going to ask you if you are able, can you please tell me what it is?
This is an NCIC return.
And what does, whose information is on that document?
Richard Earl Kern.
Okay. And what is that does that document reflect, or what does the document reflect?
The document reflects that Mr. Kern did not issue a Wisconsin driver's license.
Ever?
He's never issued a Wisconsin
Nope.
driver's license.
Okay. So, based on him never being issued a license based on that document right there, then we can deduce that he did not have a valid driver's license on August 15th.
Yes, ma'am.
Okay, thank you. Judge, I have written Exhibit A on there. If there's no objection, I would move Exhibit A, the DOT record of Richard E. Kieran, into evidence.
Any objection, Mr. King?
No, because I've never had a license. I'll openly admit it.
Officer Davis, I have no further questions for you. Thank you.
Okay, Mr. Kern, you may ask the officer any questions relevant to the case.
Now, when she was questioning you about what I had said on scene when you first showed up, what did you say? You said that I had stated that they had paused and I sped up, and then they pulled in front of me to do the U-turn, and that's when I hit them. That's not accurate. I had actually told you clearly that the gentleman had started the U-turn and then hit the brakes blocking my path.
Note that that wasn't a question.
I know for a fact I did.
Officer, Judge, Judge, I'm going to object. It's not a question here, but I would just remind.
Well, number one, that wasn't a question. Number two, that has nothing to do with what he's charged with. It has to do with the accident that led to him being charged. but it has nothing to do with the issue of him operating without a license or allegedly operating without a license. His whole fucking shtick is supposed to be that I am not required to have a license for what I'm riding on, for the vehicle that I'm riding on. That's supposed to be his whole argument. Why he's bringing up the accident is beyond me.
The court that we're here only on an operating without a valid license.
Well,
what happens in the fact that there was a crash? Nobody here is being tried for what did or did not happen there. So that crash is not what we're litigating at this point.
well,
And in fact, the point there is that you may have a civil action against the other driver, but that would be the court, and that would be the action
Well,
where who did what prior to the.
the issue I have with this,
Sorry?
the issue I have with this is I'm trying to establish his credibility. I see multiple omissions in his report. I also noticed omissions while he was speaking with her, and I have the right to bring those up, point them out.
Okay, but it's gotta be in a form of a question. You can't just you because you're not testifying right now. You're supposed to be asking him questions. You can't just say, no, you forgot to mention X, Y, and Z. That's not how that works. This is why you get an attorney.
To bring up his credibility.
You have to testify with regard to what you told him. Not to argue with him about what he said or you said, but if you have a question, you can say, did I not tell you this?
Okay. So
Exactly. The judge is basically giving him, basically throwing him a bone right there. Because the judge literally just said, rephrased his statement into a form of a question that he can do. Isn't it true that you said X, Y, and Z? Isn't it true that I told you X, Y, and Z?
Did I not tell you that the gentleman started the U-turn and stopped blocking my path so I could not pass?
So that different than starting the hesitation.
After I stated that, when I told you he actually did pull out in front of me after I started again, you stated to her that they just pulled out in front of me.
Did you not state to her that you pulled out in front of me?
They didn't just pull out in front of me. Did I tell you that they pulled out in front of me and then stopped blocking my path?
That I don't recall.
Okay. The next section is about the working light that in your report you said no operating WIS.dot approved light could be located on the bicycle. Yet there's no mention of the fact that I had multiple bicycle lights that were affixed. Or did you observe the bicycle lights that were affixed to the front of my basket that had smashed into the car?
I observed lights on the bike, but I didn't observe any Wisconsin DOT approved lights on the bike, as stated in my report.
So, is a light that is sold specifically for bicycles Wisconsin.dot approved?
Objection, Judge. The relevance here is I'm struggling to find it.
Yeah, there is, again, this is an irrelevant question because it has nothing to do with whether or not he is required to have a license to operate his moped, motorized bicycle, assisted living bullshit. Has nothing to do with it.
The relevance.
Yeah, with credibility, but for the record.
The relevance is also that there's trying to assert that I wasn't able to be seen. I mean, yes, it doesn't directly affect the license issue.
Which is why we're here! It's why we're here!
But one, it goes to the credibility, and two, it goes to the fact that I believe this whole thing, because I know for a fact Racine County has never cited a bicyclist for this. No one on what I operate.
They're going to object. These are statements. We need to stick.
Well, and I'm trying to speak directly to the judge because you brought.
You're talking at a judge. You can't. This isn't what you're supposed to be doing. You're supposed to be asking the guy who's on the stand questions, not pontificate.
Your point.
I'm trying to order food, but I can't because this asshat is saying so.
A question. You did ask him a question, and he said he did see lights on the bike, but not what he considered.
And it's common sense that any bicycle light that is sold as a bicycle light is Wisconsin DOT approved.
Again, something you can argue to me that is correct, but.
Yes, but he's saying he did not observe any WIS-DOT approved lights. And he is now trying to say that the bicycle lights that are WIS-DOT approved that he never inspected except for just to take a 2-second glance at. He's trying to say that those are not WIS-DOT approved when he did not do anything to verify. He only took a 2-second glance, and them saying that there were no witnesses is a lie.
Yeah, I'm getting kind of hangry right now. Kind of hangry.
We're getting into the realm of argument.
Okay, then let me ask the question. Did you guys actually question anyone besides me and the one actually operating a motor vehicle?
I did not know. I can't speak to other officers on scene.
Okay. Well, it seems to me like
You're pontificating again. You're making statements. You're not asking questions.
this is just a railroad, so basically I don't know how to proceed because I don't know how to address these issues directly as questions
Well, sounds like a personal
that I
problem.
need clarification on from him.
You will certainly have the opportunity to testify and explain
I'm not.
from your viewpoint what you did to qualify as a licensed driver or didn't do or why you didn't need it or whatever.
I'm trying to show that I gave clear information to him. He says he properly stored his body cam footage. He didn't issue this citation until over a month later, meaning he could have gone back and watched his body cam footage. It goes to his credibility.
Record improperly here. I would need to do questions directed towards the witness.
Well, when you guys are talking directly to me or...
No, but you can ask him, did you do something within that month to verify this or questions of that sort?
Okay, well then, what, if anything, did you do besides looking up NCIC to verify whether I was required to have a license?
All right, I just ordered myself a personal size meat lovers, pizza, and some garlic bread. There you go.
While operating what I'm operating.
Outside of looking up NCIC, I spoke to a traffic investigator about the incident, and he stated as well that in order for you to operate a motorized bike on the road, you have to have a valid driver's license and a required endorsement.
If it goes over these parameters, so you were misinformed.
Objection, Judge, that's a statement. Drawn conclusion.
Okay, my question then, based on this, and if I don't know how to proceed with this to have him take a look, but based on this information that I was handed by her, it says that what you were given was partial information. Can I have him take a look at this?
Judge, if I might clarify, Mr. Kern, that is something that I drafted as what I believe is the law that is relevant for today and the elements. So that is nothing that the officer had beforehand, and I
Hey, Juan.
Yes, but he spoke to somebody who supposedly had this information and was misinforming him. So I just want to get clarification that at the time, yes, he did take action because he was misinformed, because I do need it on the record so that when I do go to look for it, I can go and find out who is giving out that misinformation, at least to have it corrected. And that's why I'm asking. If he was misinformed after he looks at this, because then that right there would also say that the whole thing should be taken out, because did you do any...
Judge, I'm going to object here on speculation. The officer can't testify as to what somebody gave him.
I was about to ask a question, you cut me off to say I'm speculating.
And really, I'm trying to give you as much leeway as I can.
I understood that I was messing up by saying it the way I was changing it to a question, and I got cut off.
And I understand you're not a lawyer and you're not represented here, so I'm trying to give you some leeway. But he can't tell you whether or not he was misinformed unless someone else has told him that he was misinformed. Someone other than you.
Paperwork provided by a court officer that would show him that he was misinformed, so that he could now make an informed decision on whether he was misinformed or not. I heard earlier I can submit evidence. This was given to me by a court officer. If this can't be trusted, then how can anything she says be trusted?
And I understand the credibility issues, okay?
And that's why I'm asking, how can I have this submitted so he can look at it and say, okay, either I was or I was not misinformed before issuing this?
I'm going to let him look at it. And you can ask him a question. But I'll caution you ahead of time that if it's not relevant or if it's out of his answer, beyond his ability,
So,
then it may
if I'm trying to get to the point of if the citation should have been issued to begin with, are you guys going to object and say it's irrelevant? Because I have been trying to do that. I admit it's not in the same way you guys are used to or you like. I'm sorry. I'm not an attorney. I don't know the ins and outs
No shit.
yet of dealing with this because I'm just starting off. This is my first time dealing with a civil citation in court.
Now,
So I'm trying to do my best.
Show him the paper and ask him a question. I'll rule on whether or not it's admissible after I hear the objection of anything.
Now, based solely off of the last section that states the requirements that a bicycle has to exceed to become
Judge,
requiring of a license.
But the statute says not to exceed. Capable of speeds not more than 30 miles an hour. Not more than 30 miles an hour. Moped means any of the following motor vehicles capable of speeds of not more than 30 miles an hour. Motor bicycle means a bicycle to which power unit that is not integral part of the vehicle that has been added to permit the vehicle to travel at a speed of not more than 30 miles an hour. So it could be 30 miles or less capability.
Mr. Kern, I'm sorry. If there's an objection, that's why I'm speaking out, because if I let you finish and you make the record and I don't object, then I've waived it. So I'm not trying.
Exactly. Miss Prosecutor knows what she's talking about.
Interrupt you. I just
Then again, she's a prosecutor, for fuck's
have
sake.
to object when I hear it, okay? we don't have any foundation for this. This is a document that I drafted and I gave to the court and the defendant. So this officer doesn't even know what I drafted. This is an excerpt of the state statute, and he wasn't even explained that. This is, I would like to hear a proper foundation to be offering a document to the officer in the first place, and I'm struggling to see where this is going.
To, one, establish whether this should have been issued in the first place. Two, to establish if any officer did any kind of investigation to determine whether my bike actually exceeds those requirements that she brought to court to cite.
Okay. All right. Look, guys. Somebody in the chat also mentioned this. I said the definition, right, of moped and motorcycle. That's capable of speeds of not more than 30 miles an hour. Operator's license statute 343 guilty spark.05. C. No person may operate a moped or motor bicycle unless the person possesses a valid operator's license or special restricted operator's license. So even if your moped or motor bicycle cannot exceed 30 miles an hour, you still need a license. Do people not understand what I'm trying to say? No, even if it doesn't go farther than 30 miles an hour, you still need a license.
Because if I don't exceed the requirements that she's citing and bringing into court as her, whatever she's entering it as, she's the one bringing it up. She's the one making it relevant to this case. So me bringing it up and asking about it and asking to be able to question it is relevant.
Thank you, John Anderson in the chat. Thank you for saying that. If it goes further than 30 miles an hour, then it's probably classified as a motorcycle, not a motor bicycle or a moped. That's what I'm trying to get at. No, it's not a matter of if it doesn't go further than if it doesn't go faster than 30 miles an hour, you don't need a license. No, the statute says even if it is incapable of driving of going faster than 30 miles an hour, if it's classified as a moped or a motor bicycle, you still need a license.
Let me ask this question. Do you believe that you was informed as to what the law was, officer?
Oh, no, I did not do it on this one.
Thank you, that's all.
That wasn't my only concern over that, though. My other concern...
Admissible question, without any other foundation, I'm not going to allow this to go any further in the question.
So I can't ask what kind of investigation was done to determine whether my low-speed motor-assisted bicycle that is federally regulated as a bicycle.
It doesn't matter what the feds say it is. What matters is what Wisconsin say it is.
What investigation was done to determine whether it needed a license or not?
Was there any other investigation done to the best of your knowledge, officer?
No, sir.
Thank you. Fair?
Yeah. Because that right there proves my case.
So,
oh my fucking God.
No, sir.
thank you.
What investigation was done to determine whether it needed a license or not?
Was there any other investigation done to the best of your knowledge, officer?
No, sir.
Thank you. That's all. Fair?
Yeah. Because that right there proves my case.
No, it doesn't. He already testified as to how he described the bicycle or the vehicle, whatever the fuck.
So,
You have to prove it requires it.
do you have any other questions for us?
Well, who determines whether or not the state provided the proof? The judge. And so far, you haven't provided anything to contradict the the officer's testimony, which he said qualifies as a definition of a motor bicycle.
At this time, no.
See the custody, have anything for
Nothing further, Judge, thank you.
Thank you, officer.
And I do apologize if it seems like I'm trying to be difficult, but I'm not.
You have the right to make a case.
You're being an asshat.
Well, and I mean, I was trying to get it into a question form and get my point across, but I wasn't being allowed to.
All right, hopefully we were able to accommodate you.
Not fully, but
Any other witnesses that we may have?
No, Judge, thank you.
Okay. Mr. Chief, would you like
Wait,
to testify?
Officer Davis? Sorry, you just gotta hang tight just in case there's any rebuttal, okay? Sorry, thank you. We'll correct your sheet.
Okay, if you'd like to come up and stand in, sir.
okay.
You want to call him adversely, or you just want him to testify?
Yeah, he doesn't have any questions.
Okay, go ahead then.
Essentially, like I've stated, I've looked up the law on what I operate. I made sure of that. I've been doing the research for about 8 to 10 years now.
Research.
What I operate is 49 cc's or under. It goes no faster than 20 miles an hour with a rider of 70 pounds on level ground under just the power of the motor. It can exceed that if you're pedaling. Now, on the scene, I had told this officer and any that were around that I was going between 15 to 20 miles an hour when the accident occurred. I told him that about half a block away I saw the guy go to pull out, but he stopped. No lights came on, no nothing. He sat there the whole half a block. So I started pedaling again, getting back up to 15, 20 miles an hour. I had 2 lights on the front, 2 solar lights on the back, plus a turn signal laser light on the back. And the front lights were actual bicycle lights bought at a store that were smashed by the accident. When I got less than a car length behind where this gentleman was parked, he gunned it into a U-turn, and then halfway through that U-turn decided to slam on the brakes, blocking the bicycle path, which all of this was told on scene to the officers. I was thrown from my bike. I now have permanent nerve damage from what it seems in my leg, but no doctor's going to see me to actually determine it right now. And from what I understand, I'm the only one that received a citation for something that I'm not even required to have. That's both federally regulated as a bicycle that doesn't require a license, and the fact that numerous case law from both local and federal Supreme Courts have ruled that
Liar.
especially on what I'm operating, I am not required to have license or any of that. So, and I mean, like I said, even the information that she brought in, I forgot your name, ma'am? Robinson. Even her information. Now, the body weight is a little low, I'll give you that, but it's still close. I'm still around 150. But even her information, my bike falls below that parameter. Well below, considering I never go over 20 miles an hour unless I'm pedaling or going downhill. That's the only time I ever make it over 20. And I make sure that because I have a phone mounted with a speedometer app on it that runs on or offline. So I have a speedometer 24/7 whether I got internet or not. I do everything I can to be safe on the roadway. And I mean, literally in the past 8 to 10 years, I've been trying to get an operating motorized bicycle. I admit I have been hit numerous times, mostly when the bike wasn't running.
Did he just call it a motorized bicycle?
When it was before it actually got running. This last time, it was running. I literally had nothing to do with this. Only reason I can see why I'm receiving this citation for a citation I should never receive for what I'm operating. Which, what I'm operating is right outside if you want to take a look after court. It's a 2-stroke motor. Literally, if it was a 4-stroke, I could understand. And you can tell a 2-stroke from 4-stroke. 4-stroke, I can understand. Those definitely go about 40 to 50. What I operate, I don't take it over 20. And when I bought it, I made sure I didn't need a license or any of that from the guy that actually motorized it.
Well, he says he doesn't take it over 20. That's not the same thing as its max speed is 20. Not that the max speed is relevant here. But he didn't say that the max speed is 20 miles an hour. He said that I don't ride it faster than 20. Or I don't put it over 20 miles an hour.
Only reason I can think I received these citations over a month after the incident is because I have a YouTube channel where I do post both good and bad encounters with law enforcement and government officials. And I admit, every encounter during this case has and will be posted. Simply because I do like to encounter the good individuals and show them doing the right thing. But we also need to expose the bad so that we can replace them or re-educate them so that we can improve the system. And when I'm facing this, when there's no legal justification for it, they did no proper investigation to even determine if my bike was above these parameters or any parameter that needs a motor. Except for asking one person. That's not an investigation. Now, all I'd ask, well, also on top of all that, the fact that when I went for my pretrial that you sent me for, it's on YouTube already that the city attorney flat out denied me my pretrial, which I know is not legal. All I'm asking from the court is to get rid of this citation. And like I said, you can even come out, check my bike out if you want. I have no problem with it. It falls underneath these parameters and does not require a license. Period. And I mean, even the case laws that I've stated and all the others that uphold the same ruling, those include, and like I stated, automobiles.
You know what would help in your situation? If you took pictures of your motor-assisted bicycle. If you provided the documentation showing the schematics of it, the receipts or something like that, anything that can show that what you were writing did not fit the definition under Wisconsin law, but you're not doing that.
So even the first law that was cited is unconstitutional per all the case law that I have on my other phone, including the two that I cited to you, to the court, because of the fact that in non-commercial capacity.
Oh my God, commercial, I'm going to count that as commercial activity.
It is a fundamental right under life, liberty, and the pursuit of happiness to travel on the roadways. And that's been upheld every time it has gone to the Supreme Court. I'm not trying to push for that to be thrown out. I understand that's a bigger process. I'm just hoping that the court will actually uphold justice and remove this citation for the operating a bicycle without a license, which everyone I talk to about laughs at that.
Yeah.
Even looking at the bike, they laugh about it. So that's all I have to say.
Any questions?
No. They're laughing at you, not with you.
Gas in the motor, Mr. Kern?
Gas and oil mix.
Okay, thank you. Nothing further. Thank you, Mr. Kern.
Yeah. I would like to also clarify that the other thing that makes it a low-speed motor-assisted bicycle is the fact that, one, it has two operating pedals, the fact that you cannot start from a stopped position and just straight hit the gas and go. You have to pedal it in order to get up to a certain speed before kicking the motor over. Otherwise, it'll turn the motor off.
I mean, isn't that how mopeds operate? I don't know. I've never ridden a moped before in my life, but I thought that that's standard practice.
And lock up the back tire. So you can't just hit the gas and go from a stop sign or any of that. You have to pedal it to even start the bike. And that is another thing that classifies it as a low-speed motor-assisted bicycle. So,
Thank you, sir.
yes.
Appreciate that. Any further witnesses you wish to call, Mr. Grant?
I would have had some, but I wasn't able to get a hold of them for court today. And that's actually witnesses to the fact that the officers only talked to me and the person in the car that caused the accident. No one else. But since I couldn't get them to come today, all I can do is assert the fact that I've been informed that by numerous people that actually live on that block.
All right, thank you.
Can I step down?
Yes, please. There's nothing further planned either from the city or from the defendant. I'd like for a short closing statement first of all from the city.
No rebuttal here, Judge.
No rebuttal.
In that case, could you just summarize your position for the court?
Thank you, Judge. I just want to say that 2 citations were issued here. Mr. Kern stated they were issued a month later, but I would say that that's well within the 2-year statute of limitations. We proceeded with only one today. There wasn't any testimony other than from Mr. Kern in regards to the actual accident that occurred, because it really is irrelevant in regards to the citation that was issued. The way I see it, after breaking down this particular statute, this defendant within the city of Racine operated a motorized bicycle without a valid license.
Bam.
Wisconsin statute section 343.05 3C states that no person may operate a motor bicycle unless that person possesses a valid operator's license or one of two forms of a restricted operator's license. I would note that those restricted operator's license by statute are DOT approved. So there's an application and it is tracked by DOT. So the NCIC or the DOT record that was submitted shows that there was no valid license whatsoever issued to Mr. Kieran, which would include any type of restricted operator's license. And that would also be true for August 15th of 2021. So basically, the city has to show clearly, satisfactorily, and convincingly that this defendant did operate this particular bike within the city. So Mr. Kern identified himself. He put himself in the incident. He admitted it to the officer. He even spelled his name for him. So I don't believe that there is any identification issue here.
Nope.
Mr. Kern put himself at the scene. We know that that was at the intersection or near the intersection of Wright and Thurston. So we know that is within the city of Racine. So I believe that there is jurisdiction here, and we have checked the box for venue. Third, he operated a motorized bicycle. Mr. Kieran put himself on the bike in this location, and he told us exactly when he sped up and when he stopped. So he has put himself on the bike, which checks the box for the operation. I know there's a disagreement as to whether or not it's a motorized bike, but the state statute does help us out here. The statute has a definition section in subsection 30 within 340.01 that serves for definitions throughout the traffic code. And a motorized bicycle is a bicycle to which a power unit that is not an integral part of the vehicle has been added. And we have a bicycle, according to the officer,
Pizza's here.
Bicycle where a gas and oil combination is added to the motor to propel the bicycle. There is no limitation within the statute that you have to not be able to pedal it first or that it has to take off solely propelled by the motor. It just says that it has been added to permit the vehicle to travel at a speed of not more than 30 miles per hour. So Mr. Kieran has given us his weight, which includes a 150-pound rider on a dry level surface. But the key here is that it goes not more than 30. It doesn't say between 20 and 30. It doesn't say less than 20. It says not more than 30. So based on the officer's testimony and Mr. Kieran's narrative, he basically is stating under the Wisconsin statute that he did operate a motor bicycle. So, and I believe I skipped to, or I mentioned the fourth element first when I said without a valid license. The Exhibit A, which was entered into evidence, shows that there is no valid license that has ever been issued to the defendant. So based on the Wisconsin statute that defines a motorized bicycle and then requires that the operator of such bicycle have a valid license, I believe that all of those elements through the officer as well as Mr. Kern's testimony will show the court that clearly and satisfactorily and convincingly that he did violate statute 343.05 through C. And I just wanted to note that there's a description. Mr. Kern put a lot of emphasis on how fast his bike, or lack thereof, or that it doesn't go very fast. If it's under 30, then it is a motorized bicycle. And if it can get over 30, then it would be a motorcycle.
Thank you! Thank you! For God's sake, I'm glad. Now, does chat understand this now? Does chat figure this out? That's what I've been trying to say the whole time.
On the definition in the statute. And a motorcycle also requires a license. So no matter how fast this bike goes or doesn't go, it would to a bicycle. Thank you.
Sure. You may give me your closing arguments.
Ooh, that's a lot to unpack. First things first, as I stated earlier in the case, I was informed of both the 340 and the 343. 343 is still on the books, even though it's unconstitutional.
Okay.
And 340 has been repealed. You cannot use a repealed law
Where's the evidence that it was repealed?
to justify a classification when it's been repealed as a classification, and the federal classification classifies what I'm operating as a bicycle. Nowhere in all the United States.
So he's relying on his own opinion to claim that the existing state statute was repealed and therefore the federal statute is default, and because the federal statute does not require a license, he's not required to have a license. This is his strategy. Strategery.
Does a regular bicycle, which is what I'm operating as deemed by federal government, nowhere does it require a bicycle to have a license or anything like that. Yes, it requires that I have the turn signals, that I have lights to the front and back. It does require all of that, but it does not require a license or insurance. I have to follow all traffic laws.
All right, we're done.
As in following the traffic signs, turn signals, stuff like that. But it states clearly that because it's regulated as a bicycle, does not require a license. That's federal. On top of that, she wants to quote the whole no more than. This right here is almost identical to the federal ruling that says the exact opposite of this. And I believe that is why this law was repealed. And that is why she was trying to keep me from bringing it up to him. Because she brought it in as just an extra bit of information that she might scare me with into taking whatever from this case. I'm sorry, I'm not going to back down on my rights, and I'm not going to back down when the government or government officials, not you necessarily, are coming after me for something they shouldn't be. And honestly, as a judge, I'd hope that you would see this and understand that she even admitted this wasn't a law when I was trying to bring it to the officer. Meaning she knows that the 340 is repealed. I've looked up numerous times over the years bicycle laws for gas-powered bicycles in Wisconsin. Every single time it comes up, there are no laws on the book currently because this one was repealed. It can't be used to convict me or to charge me with anything at all. And if I'm operating what's not federally regulated as a vehicle, moped, motorcycle, I'm not required to have a license. So, in closing, I'd hope that you'd see the facts for what they are, on top of the fact that citizens do have the fundamental right that's been upheld by the Supreme Court to travel on the roadways. Only if they're not operating for commerce. Commerce, yes. License, registration, insurance is required because it's undue use on the roadway, not normal wear and tear.
So, I just want to make sure I understand your argument. And one is that Wisconsin statute, section 340, 305 is unconstitutional.
Yes.
And number two.
Well, the way it's written is.
Okay, and number two then, that Wisconsin statute section 340.01 has been repealed.
That's all my research points to that, yes. And I've tried looking it up different times. I just looked it up yesterday.
Does it cost you any?
Yeah, I bet you did.
Judge, all I can say is that I drafted this yesterday and I copied and pasted the statutes from the Wisconsin statutes online. But I want to emphasize this is my version of what I came in today to prove. I know that only the court can direct as to what the law is. This is my excerpts to try to hone the trial, basically a roadmap. But the only thing I can state here is that these are excerpts from the statute that I copied yesterday.
And, Your Honor, so I can clarify that. When I've done my research on my own before I was given this statute, I never found this law. The only way I found this law was because I was given the statute at City Hall. So if you know the statute, you can look it up easy. If you don't and you're just looking for general laws in Wisconsin, it's not active.
Are you trying to...
She can definitely look it up and say, yeah,
Is he seriously trying to call out the prosecutor for her legal research?
found this law. It's not admissible in court if it's not on the books. Because it was repealed for a reason.
Well, that is something that I am personally then going to have to look up.
Okay.
And so what I'm going to do is I'm going to make my ruling at a later time in writing. And after I've had an opportunity to do my own research on it, and I will then start sending copies to you. With instructions, should I decide in your favor, then the case will be dismissed.
And that's all I ask for.
Then you have, of course, the right to appeal that. And along with a decision, if I were to decide against you, I would include written materials explaining what your rights are in terms of an appeal, both if you wanted a new trial, or if you wanted, that's called a de novo trial, or if you wanted just a trial on the record that we have here from this court.
Okay. And you'd actually, if you guys do make it that easy for me, you'd be the first court to make an appeal process easy. At least here in Racine.
We'll try to do that. Thank you.
And I'm hoping it doesn't come to that.
Thank you very much.
Thank you, sir. You too. So, we're going to gather up our paperwork here that we have now collected.
Why is it all draft? Is that his paperwork?
Oh, dang it.
And that's the end of it. Which means it's pizza time. All right, that's it. Let's go through the rest of the super chats and we'll call it a night before I get crazy.
Do you want me to read them? Or are you going to read them?
Do you have it, dude? If you have it up front, go for it. Starting with Miss Mandy herself. You don't know. I'm not gonna make you do your own super chat. Miss Mandy sent a $2 super chat. Whoever that is. I mean, whatever. Probably a troll. Sent a $2 super chat. Someone play for me. LOL. I don't know what that means, but whatever. All right, go ahead. Your turn.
RA sent a $9.99 super chat. The hubris of the Sovsits thinking they are so smart that they have found a driving loophole that no one else has considered.
Yeah, it's only the loophole that they've tried to employ for like the last 40 years
Well, you
without
know,
success.
no one else has thought of it. Arrow Scout sent a $4.99 super chat for some chicken wings.
Thank you
So you
very
can
much.
forward
I
that
did
over
get
to me.
some pizza. So it's pizza time. But thank you very much, Air Scout.
Yay. Deacon Fatal sent a $5 super chat. Just pay the ticket, cheapskate. This was a waste of time, including yours.
Probably.
That's it.
Well, I do see Paul Berry send a $2 super chat, giving us a direct link to Wisconsin statutes, to the exact place where we need to go, which is where I went to, I went to Lexus, and it does not say anything about anything being repealed with regards to his definition of a motorized bicycle, whatever the fuck. So, fuck that guy. Excuse me. I see Gary is all about them dulcet tones. Miss Manny's dulcet tones, her choice of vernacular and proper method of articulation. Yeah. I'm actually waiting. The pizza was fucking hot when I got it from the delivery guy, so I'm actually waiting for it to cool off a little bit. You know how it is. You need to let the pizza set, or else all the fucking cheese and all the toppings are gonna slide off of the bread, and it's just gonna be a complete mess. So I'm letting it set for a little bit. All right, chill.
Do you hate it when they deliver hot food?
I love it when they deliver hot food, but I also know that I gotta let it set for a bit.
Yeah, I was being smart.
I know you're being smart. I was still correcting you regardless. You do this to me all the time, Mandy. I don't know why. It's like you pick on me for no reason other than to be mean.
Love you, Artie.
No, you're not Kick. All right. Don't play that with me. I don't want that mess.
I don't want you to love me. Just love you.
Oh my. Oh, he did respond. He responded to my comment. Oh no. Oh, the poor bastard. There was another video I could do. Oh, what was it? Thank you for TNPR 4002 for the $10. Artie's Corporate Fiction doesn't have to rely on food to make a complete mess. He is a complete mess. Thanks. Thanks, buddy. Happy Friday to you too. I want to watch this, but I want to save it for the next time I'm on with my brother. Sheriff and police sergeant threatened to arrest each other. I'm saving that for my brother for our next collaboration. I still got about a third of a beer left, so I got to figure this out now. I mean, we could watch cat videos, but I mean, that just seems cheap. But if you guys are done with that mess, I completely understand if you guys want to tab out. It happens sometimes on Fridays. So on your way out, if you're calling it a night, thank you very much for being with me. Hit that like button before you leave. It's always appreciated. But if the rest of you degenerates want to see me act the fool, I mean, we'll see what happens.
And there was much rejoicing.
More super chat.
Yep. You go ahead. Go ahead and say it. Yeah.
Okay, Artie's corporate fiction. I was trying to do something besides screw Philanders for once, but Joshua Lee is here, so I got to do it.
Oh my God! God damn it! Oh, Donut Operator. This one I saw this one before, but we can watch Donut.
Donut here. What's this on Donut's Raw Police Footage YouTube channel? I just realized that channel hit 100K. I'm about to get my fifth play button. Yay! Police Canine's first bite. Oh my. A Bork Bork gets his first nom nom. Hell yeah, brother. That sounds like a good video. Let's go ahead and break that down. Obligatory YouTube manual reviewer. I'm a former police officer who's breaking this video down in an educational manner. So what had happened was, before you say, oh my God, that dog is eating that man, let me...
Happy Friday, Artie. Thanks for the stream. Hashtag nothing at all.
Thank you, Joshua Lee, for the $100 super chat.
Literally just took a bite of food and spit it halfway across the room.
Oh my God. Thank God I wasn't eating at that point. Thank you very much, Joshua. You and TNPIR are just, what are you guys doing to me? But thank you very much.
These three incredibly intelligent looking men did a big oopsie. And by big oopsie, they carjacked someone and murdered them. Wait, this guy right here
Holy
with this
shit.
tattoo carjacked someone?
I mean, if you got a neck tattoo of somebody, of a hand holding a gun to your face, I don't know, but you might have some judgmental opinions of you at a job interview. I don't know. Maybe.
No way! May 23rd, Dealin, Florida Walmart. At around midnight in the Walmart parking lot, they approached someone with a gun, and the person ran inside Walmart with their keys, and they didn't get the car. Like I said, they're super smart. Around an hour later, the same suspects shot and killed someone for their car in the Florida Technological College parking lot. They're not very good people, and that makes this so much better. The three men were indicted for murder, and wouldn't you know it, two of them were already in jail for a different carjacking. But Bacon here, that's his name, Bacon here, he was still on the run, but not for long. Some jump out boys were doing some surveillance looking for Bacon already because, wouldn't you believe it, he had aggravated battery with a firearm and aggravated assault with a firearm warrants that had nothing to do with the incidents we...
Bacon was recently seen purchasing a 60-round AK-47 magazine at New Smyrna Beach gun store.
We already talked about. The jump out boys spotted him and two other guys, formed a perimeter, but somehow he got through the perimeter and took off on foot. In comes Deputy Whitson with the Volusia County Sheriff's Department and Canine Red. Now the cool thing about Canine Red is this is his very first bite.
He's a rookie. The Bork Bork Nom Nom's a rookie. He's green.
He's running through the church.
As you can see, Deacon. You can't see Deacon. This is the body cam footage is June 30th, 2022. So a week and a half ago.
Canine's here. Tell me where to go, guys.
Shut the fuck up, Alpha.
All right. Just kick that loud. One more time. There you go. Around the fence? Yeah, he'll bite you, so watch it. Do you see him? Oh, right here. Come here. Pop him, Red.
This goodest boy is tracking his little heart out, and wouldn't you know it, that little cockroach is hiding behind a washer and a dryer.
is that? I think that's a leg. That looks like a leg. Right there. I think that might be a leg. But honestly, given the circumstances, we're dealing with one individual who was part of the actual murder and carjacking. Obviously dangerous. I have no issues with releasing the hound.
This is a pretty dangerous situation right here because they can't see his hands and they know that he's armed and dangerous and he's already killed people and assaulted others with a firearm. Red don't care. Red just want to nom nom.
Pocket Red! Pocket Red! Pocket Red!
Get him!
Pocket Red! Pocket Red! Get your hands up! Hands up! Let me see your hands! Pocket Red! Good boy, Red! Pocket! Pocket! Good boy, Pocket Red! Pocket! Good boy! Good boy! Get him out! Pull him out! Pocket Red! Good boy, buddy! Good boy, Red! Pocket! Pocket! House! Watch that bad man, buddy!
All right, got him out.
Good boy, Red! You watch him, Red! Watch that bad guy, buddy! Ah, good boy, buddy! Good boy!
Good boy!
Buddy, got a good boy!
Reminds me of Arthur from Red Dead Redemption 2. That's a good boy.
Yeah, good boy, Red! That a good dog! Everybody clear? All right, Red. Come on, buddy. Butts! Butts! Butts!
I love a happy ending. Did you see how happy Red was? That was awesome.
Watch that bag out, buddy. Ah, good boy, buddy. That a good boy.
Anyways, if you want to help support the channel, guys, head on over to donutoperator.com, get some super sweet merch, or subscribe to one of my other channels. Other than that, everyone, please have a fantastic day.
Backer.
We're not going to see this because this one's pretty brutal. Yeah, it's pretty rough. In fact, the one in the thumbnail I actually already showcased to you guys a while ago. It's pretty damn rough. But I'm gonna end it with the North Hollywood. I'm gonna end it because I think he does a decent enough job. Even though I feel like you, me, and every millennial out there has seen the North Hollywood bank robbery probably live. I can't recall whether or not I saw the news footage of the North Hollywood shootout live. I just know that I saw the recap at the time that it happened, right? But the North Hollywood shootout was a fucking wild ride. For real. And you're right, Gary. I think I might go grab a slice before watching this. This is wild. Well, Thea, I mean millennials as a minimum, as the minimum generation, right? Zoomers wouldn't know shit. But I mean, millennials at a minimum would know of the North Hollywood shootout. All right, I'm back.
Friday, February 28th, 1997. Two professional bank robbers overtake a North Hollywood branch in Los Angeles. Sporting a military-grade arsenal and covered nearly head to toe in body armor. And as fate would have it, an LAPD officer in the right place at the right time witnessed the moment the gunman entered the bank. The police soon had the men surrounded, expecting the men to barricade inside. But instead, the two robbers swiftly exited the bank, spraying over 1,000 rounds at police. Over 44 minutes and 2,000 rounds exchanged, the streets of North Hollywood turned into a living hell.
By the way, this is Popo Medic. Shout out to Popo Medic. Also, Popo Medic has some of the sickest synthwave soundtracks. I actually love it. I've been on a synthwave kick in terms of music for like the last month. So I'm really loving his choice of ambient music. I almost want to play Cyberpunk.
The two gunmen behind the North Hollywood shootout first met at a Gold's Gym in Venice Beach, California. Larry Phillips Jr., a Los Angeles native and proficient real estate scammer, and Emil Matasarinu, a Romanian immigrant and college graduate with an above-average IQ. They were close in age and talked everything weightlifting and bodybuilding and whatever else the fuck gym rats talk about. Chicken breasts, probably. Despite the contrast
Skinless chicken breast
of their upbringings, the two quickly became close friends outside of the gym. They bonded over firearms, philosophical ideas, they talked about their tough childhoods, and their mutual hatred for authority, as Larry Phillips Jr. grew up around an ex-convict father who struggled
fuck the establishment, am I right?
With the law, and Matasarinu, who grew up watching his home country of Romania violently collapse in 1989 on live TV. Their hatred for the world and the figures who ran it ran deep. In October of 1993, the two found themselves in some serious trouble when they were traffic stopped by an undercover Glendale detective while operating a stolen rental car. When the detective made contact with the vehicle, Phillips gave the officer a fake name. He then asked the men who the vehicle belonged to which Matasarinu replied that the vehicle belonged to Phillips' mother. And after making checks, the detective ordered Phillips to step out of his vehicle, at which point the detective located a Glock 17 with a 33-round extended magazine in Phillips' waistband. Matasarinu is still inside the vehicle, then tucked his pistol beneath the seat. Backup arrived, and both men were taken into custody. The vehicle was seized, and a laundry list of weapons and suspicious items were recovered from within, ranging from a Norinco, 1,700 rounds of 7.62, 3 Chinese-made 75-round drum magazines, 6 smoke bombs, 2 IEDs, a gas mask.
Fucking hell. By the way, guys, if you look online and if you see the made-for-TV movie of the North Hollywood shootout, do not watch it. It is hot garbage. There is a documentary by Nat Geo or Discovery, I can't remember who produced it, that is like worlds better at recreating what happened than that shit-ass movie. Do not watch the made-for-TV movie, for the love of God. Also, all right, moving on.
Mask, wigs, 3 different California license plates, and 2 spray cans of gray hair coloring. That's right, these jokers were locked and loaded with some Just for Men. Now it's a party. Larry Phillips was charged with conspiracy to commit robbery, grand theft auto, unlawful weapons activity, carrying a loaded and concealed firearm, and felony perjury. On December 27th, both men were only sentenced to less than 1 year in jail.
Less than a year in prison for all of that. Less than a year. Ah!
On June 14th, 1995, in the Los Angeles neighborhood of Winnetka, at approximately 12 p.m., Phillips and Matasarinu stalked a Brinks truck. They followed the armored vehicle until it made a stop. They watched as the guard got out and made a delivery. As the guard returned and opened the back doors of the armored truck and was at his most vulnerable, Phillips and Matasarinu opened fire with AK-47s. Both guards were shot, and $120,000 was stolen.
The
Brinks guards luckily survived, and the robbery quickly made headlines. Given the level of violence, tactics deployed, and weaponry used, the FBI took exceptional interest. who they deemed at the time the AK-47 bandits. And it wasn't long until they struck again. On March 27, 1996, in the area of Woodland Hills, Phillips and Matassarino attempted to overtake another Brinks truck, but miserably failed. They once again stalked the armored vehicle and opened fire after it stopped, but the driver took off. They chased the vehicle briefly before fleeing the scene, and once they got away, they ditched their vehicle and set it on fire. Despite the recent failure, only 2 months later, the men graduated to bank robbery. And on the morning of May 2nd, they initiated their first ever takeover heist. They kicked open the bank doors, fired warning shots into the ceiling, swept the vault, and walked out in under 6 minutes with nearly $750,000.
Woo! This is straight up GTA shit right here.
And high on success after making it out clean, they hit their second score only 29 days later. On the morning of May 31st, Phillips and Matassarino took over a Bank of America branch in Winnetka. Walking out once again with just under $800,000, accumulating a net worth of approximately $1.6 million in 30 days. And by this point, the FBI Violent Crimes Task Force and local law enforcement were rattled. The suspects were virtually uncatchable. It was evident that the two robbers had gone from violent outlaws to swift professionals in a short period of time, prompting the FBI to change the duo's name from the AK-47 Bandits to the High Incident Bandits.
I mean, Deacon, that's a good question. But I don't know what it was like in 1997, how they dealt with bills, right? How they could actually launder the cash. I mean, that's a good question, but I don't think we'll ever know.
Over the next several months, a massive joint operation spanning multiple law enforcement agencies within Los Angeles County sent officers to stage outside of banks and other potential targets of the high incident bandits. But the robbers at the time went on hiatus, upgrading their arsenal and mostly planning their biggest score yet. Phillips and Matassarino narrowed down their options to branch 384 of Bank of America, located in North Hollywood, California. It was the largest bank in the area by far and had the potential to net them at least $2 million for 10 minutes work. It was the optimal location for many reasons. Professional bank robbers tend to hit branches located on street corners for a better escape egress. Branch 384 was a single building lot, meaning not only was it a corner branch, but it had two corners of the lot.
I mean, tactically, that's fucking amazing. But at the same time, given their history, they would have to know that the police and the bank knows that they're in a vulnerable situation. I don't know, maybe.
With both freeway access nearby and city side streets leading into the valley. It was the perfect stage for the perfect heist. They chose the date of Friday, February 28th, and they loaded up for war. They attached level 3A Kevlar body armor to the front and back of both their torso and extremities, basically making them pretty much invincible against the police who have 9mm. And speaking of bullets, holy shit, they loaded out with
still notwithstanding the Norco shootout. Still, in 97, the cops didn't have patrol rifles. All they had was 9mm sidearms or revolvers. They did not have high-powered rifles at all, or in regular distribution to patrol vehicles. Only SWAT had this. So bear in mind.
Marincos with full auto conversions, 75-round Chinese magazine drums, a semi-auto HK91, two Berettas, and a fucking Bushmaster XM15 dissipator. They then loaded several thousand rounds of spare ammunition into the trunk of their white 1987 Chevrolet Celebrity. and both men knew there was no going back. They dug their graves in their past robberies.
Headshotties, you're right. Blueberry said headshotties.
They knew they would be facing life in prison. Unspoken, but likely even fearful of one another, and the idea of their counterpart cooperating with authorities in exchange for a lighter sentencing. They knew from here on out, contact with law enforcement could only end one way. And on the morning of the robbery, the men each took an unknown dosage of phenobarbital, a central nervous system depressant to basically Master Chief the shit out of their nerves.
Yeah, in other words, basically no pain. Basically dull any sense of pain on them. Fucking hell.
Suited up, drove to the bank, synchronized their watches, and at 9:17 a.m., Larry Phillips and Emil Mastorino clashed through the doors of Branch 384, firing rounds into the ceiling and declaring aloud, "This is a fucking holdup." While on routine patrol, as fate would have it, LAPD patrol officer Martin Perello entered the bank's intersection of Archwood and Agnes when he spotted the two heavily armed gunmen entering the bank at 9:17 a.m.
Again, it's one of those things where it's sheer coincidence and luck that can turn anything around. A patrol officer happened to notice the two guys get into the building at the point of the robbery, leading to what we see now.
And just like that, the milliseconds before the heist started, it was already over.
5840, requesting assistance. We have a possible 211 in progress at the Bank of America. Bank of America. Located in Norfolk District. We have shots fired.
Inside the bank, the gunmen took over, while continuing to open fire into the ceiling. And after gaining everyone's compliance, Phillips and Matasarinu began shooting at the bulletproof door that gave access to the bank tellers and the vault. The door, which was only made to withstand small caliber ammunition, broke open after a few shots from their modified Norinkos. The men then forced the tellers to fill their bags with the money from the vault. As they held the door, watching over their shoulders, they realized there was a big problem. There was way less money in the vault than they had anticipated. The adrenaline partnered with the intense stress.
Popo Med doesn't mention this, but I can recall from the documentary is that it was sheer bad luck on their part that this particular day happened to be a day where there was like a transfer or there was something going on where the bank was transferring money from one branch to another or something like that happened to have their actual cash reserves at the bank like specifically low or particularly low that day.
Stress led the two men to unravel, and bursts of gunfire continued solely out of rage. Matasarinu became so enraged that he emptied a 75-round drum magazine into the vault, destroying the rest of the money. In total, the tellers only packed $303,000. Meanwhile, outside of the bank, LAPD officers Perello and Farrell enter the perimeter of a parking lot across the street and are soon joined by multiple officers rushing in to the area. An anxious Larry Phillips noticed the silence outside of the bank. There was no longer any foot traffic outside, or even a single car on the usually busy roadway. He walked halfway out of the bank and heard nothing but the freeway noise coming from a half a mile away. And in that moment, he realized the police were waiting. At which point both men could hear sirens of the cavalry of the LAPD responding, as well as the sound of exploding dye packs in the money bags, rendering
dye packs!
The bills completely useless. The officers outside were coordinating what they thought would be a barricade situation.
Nope. It's not going to be a barricaded situation. Not a chance.
Until Larry Phillips stormed out of the North ATM lobby entrance, spraying rounds at officers with his Norinka, immediately injuring 7 officers and 3 civilians from 200 feet away. They returned fire at the robbers, but their 9mm had little effect on the heavily armed gunmen. LAPD officer James Zaborvan, only a few months out of the academy, gets a shot off on Phillips, wounding him. The gunman turns his attention to Zaborvan, who dives across his fellow officers.
Okay. I apologize for pausing so much, but Popo Medic kind of overlooks this point of what he just said, where that rookie officer shot and wounded one of the suspects. That wound is actually very important according to the documentary that I watched. And we're going to see why later on. That how he wounded the suspect will matter.
Blocking the shot. He then seeks...
Also, Omega, thank you for saying that, because these guys were decked out basically like juggernauts out of Call of Duty.
Cover into a nearby dental office, where a dentist by the name of Jorge Montez quickly turns his dental office into a makeshift emergency room. And at this time, the elite members of the prestigious LAPD SWAT team arrived on scene. Many of the members, at the time, were even founding fathers of the LAPD's first ever SWAT team, who had a fierce reputation and a highly successful rate of solving the problems within high-risk incidents. Phillips retrieves the HK-91 and begins sniping news helicopters with 308, hitting a KCAL-9 chopper's rear stabilizer, until a group of officers who raided a nearby gun store,
which they did. There was a nearby gun store, and the officers just like, we are commandeering your shit to solve this problem.
To obtain higher caliber weapons, returned and landed a shot on the HK-91, disabling it. Phillips picked back up his Norinco until his weapon stovepiped.
So that's where
not knowing how to
that's where he said
clear
it.
the malfunction, he pulled out his Beretta and continued firing at police. And suddenly, realizing it was the end, Larry Phillips took his own Beretta and ended his life.
Okay, there. Now we're gonna pause. So, Hobo Medic gets it kind of wrong here. Remember what I said when the officer said he got that this guy got wounded, right? So my understanding is, and based on the documentary, is that he knew how to clear a stovepipe jam. If you don't know what a stovepipe jam is, when the spent casing is locked in the ejection port, and it's like out, like, so it looks like a stovepipe on the side of the gun. Normally, what you do to clear a stovepipe jam is you use your thumb to eject the casing out of the round and go for it. The problem is when he, how he got wounded was that he got wounded in his thumb. And so he was not able to actually clear the stovepipe jam effectively because of his wound. That's why he ditched the rifle and took out his Beretta. That's my understanding based on the documentary as to why he got rid of the gun. I understand that there are other factors that could have involved that, but that's the likely theory as to why he ditched the rifle after his gun stovepipe. Because the reason why they say that is because they found the AK or the Norinco with a stovepipe jam on it still. So, and then eventually he took out his Beretta, started firing, and then you could probably find it online. He pressed his own off button, like so. I know because I saw it in the reviews, and I've seen it myself. He presses his off button like that, but obviously Public Medic's not going to show that.
Matasarinu tried to escape by hijacking a civilian's truck, but failed. The SWAT team saw this and took advantage of Matasarinu's exposed position and moved in to engage him while taking cover behind a patrol vehicle. The SWAT team opened fire, but they couldn't find an angle on Matasarinu, taking cover behind the engine block of his vehicle. LAPD SWAT officer Rick Massa decided to prone out and found the exposed feet of Matasarinu, got a good sight picture, and opened fire, hitting Matasarinu twice in the ankle. Matasarinu collapsed and began skipping rounds towards the SWAT team from beneath the vehicle while laying on his back. And with Matasarenu's body now exposed and still skipping rounds towards SWAT officers, the SWAT team opened fire. And after being shot 29 times, Matasarenu surrenders to police. As they secure Matasarenu's weapon and place him in handcuffs to search for additional weapons, Officer Rick Massa stands over him. Matasarenu looks up at Massa and asks him to finish him off, to which Officer Massa declines and says, "I'll see you in court." Matasarenu succumbed to his wounds and died 56 minutes later. As the deadly shootout...
Now that ends up being a controversy by the family because they say that they should have provided aid, this and that. The LAPD said that the area was not secured enough for the paramedics to come in. That remains a bit of controversy, but ultimately he does succumb to his wound.
Shootout came to an end. The SWAT team entered the Bank of America to rescue the employees and customers from the vault. After the incident occurred, the LAPD realized the importance of firepower after realizing their 9mm fucking sucked. And they received 600 M16s from the Pentagon, officially birthing the requirement of patrol rifles.
Thea Thomas says the family sued and the LAPD settled.
1 year after the incident occurred, 19 LAPD officers received medals of valor and were even commended by then-President Bill Clinton. Despite the injuries, the shootout is regarded as a success for police, who were severely outgunned and managed to prevent any civilian or officer fatalities. The pop...
Yeah, that's the most amazing thing about this entire venture. Other than the suspects, nobody else died.
Culture and lore of the North Hollywood shootout runs deep. From a Megadeth song to a made-for-TV movie, countless...
which was a shit thing.
...documentaries to an op-ed in Rolling Stone magazine. It's estimated that Phillips and Matasarenu fired close to 1,200 rounds, with the LAPD returning close to 650 rounds. The North Hollywood shootout will always be regarded as one of the most dangerous confrontations between robbers and police that America has ever seen. Hey guys, if you enjoyed this video...
Fucking epic by Popo Medic.
Tuesday.
And then I got another little bit left. No, you're right, Deacon. It does not happen often, especially when you're dealing with two guys who do not give a fuck, having high-powered, fully automatic rifles, multiple officers, body armor. It's just the fact that no civilians were killed or cops killed is wild to me. But this is a story I never even heard about an SAS operator in Nairobi.
January 15th, 2019. A British SAS operator on a mission to train local Kenyan defense forces quickly found himself in the middle of a 2-day siege at the luxury Duset D2 complex in Nairobi. The 5 gunmen unleashed fury as hundreds of innocent civilians ran for their lives. But not before the solo operator grabbed his weapon and his kit and stormed in, self-initiating an off-duty rescue mission. And after a 19-hour game of cat and mouse, the lone operator saved hundreds of lives and took the lives.
Yeah, I'm going to say I never heard of this situation until Popo Medic posted the video. I've never heard this before.
Of the enemy. In 2019 alone, there were over 6 terrorist attacks in Kenya, and over the last several decades, terrorism in Kenya has run rampant throughout, from the 1975 Nairobi bombing to the 2013 Westgate Mall incident. And since its creation in 1895, East Africa has been at the nexus of several political disputes that revolve around the political conflicts of the Middle East, as Kenya has remained an ally of Western governments and is host to several sensitive Western interests, including U.S. and British military bases. And with poverty, weak borders, corrupt or incompetent police, and the rapid rise of extremist groups, Kenya and other African nations have quickly become hotbeds and easy targets for global terrorists. And
all right, we're good. Look, I'm just gonna say it right here. We're watching the video as it is, as it's done. There's a lot you can unpack when it comes to Africa, its state, its borders, and in its history for sure. But for now, for tonight, for this video, we're going to focus on the here and now. Just saying that there's a lot you can unpack there, but we're not going to get into that.
And the Kenyan army has yet to contain the influx of terrorism moving in from Somalia.
Deacon.
And sadly, too many Kenyan soldiers have died trying. At the forefront of Kenya's counterterrorism efforts are the Kenyan Defense Forces' well-armed and well-trained special operations.
They had scars. Did I just
Counterterrorism efforts are the Kenyan
They're equipped with scars. Damn.
Defense Forces' well-armed and well-trained Special Operations Forces. The Kenyan Special Operations Regiment, the 30th Special Forces Battalion, and the 40th Ranger Strike Force, who have all received their training from both U.S. and British Military Special Operations Command, such as the U.S. Army's highly capable Green Berets and the United Kingdom's ultra-secretive Special Air Service. And in January of 2019, an SAS team was sent out to do just that.
See you later, Rare. The fucking soundtrack, baby.
Amongst the SAS team was a team member by the name of Christian Craighead, a seasoned operator who first joined the British Army at 16 years old in 1992. He began his career as a junior paratrooper before coming of age and moving onward to the paratrooper regiment, which for comparison to the United States, a British paratrooper is the same thing as an Army Ranger. After serving 3 years as a paratrooper,
Yeah, no shit. I mean, I knew that.
Craighead then joined the Pathfinders, which again, for U.S. comparison, it's like MARSOC. He deployed with
what is MARSOC? I mean, I know SOC, Special Operations Command, but I don't know what MAR is. MAR.
Pathfinders to Iraq during the 2003 invasion of Iraq, where he led reconnaissance missions. And around 9 years later, he attended and completed the SAS's notorious 6-month-long selection program and joined the SAS regiment. And in true SAS fashion, the rest of his history is lost and remains untold, as the ethics of the Special Air Service are true to form of the phrase, the quiet professionals. But the SAS's legendary exploits over the years have
Archangel Marine Special Operations Command.
often superseded their efforts of secrecy.
The end came with an assault on the building by the Army's Special Air Services Regiment, the SAS.
And at the tip of their spear lies the 22nd SAS Regiment, the Special Air Services.
Who dares wins. Metal Gear Solid, anybody? Look, the reality is, SAS were the OGs before there was a special, before the U.S. even knew of a special forces. SAS was the OG.
Tier 1 unit, of which Craighead belonged. And when his seemingly peaceful training mission in Kenya took an unpredictable turn, Craighead delivered the gunman an unpredictable turn of his own. And on the afternoon of January 19th, at approximately 3 p.m., at the 5-star Duset D2 hotel complex, as guests were having lunch and shopping around, 5 Kenyan nationals of non-Somali descent were moments away from executing a calculated attack. The terrorist cell had traveled to the complex from their home base located in Somalia. Armed with AK-47s, hand grenades, and an IED, the men staged outside of the complex. The 14 Riverside complex in its entirety is one of East Africa's largest and more upscale developments, consisting of banks, restaurants, executive offices, and the hotel itself. A stage with stark contrast to the barbaric attack that was soon to unfold. At approximately 3:30 p.m., one of the insurgents breaks off on his own and enters the complex, where he locates and fronts the outdoor patio of the lively lunchtime rush of the Secret Garden restaurant, shouting aloud in Swahili before committing to the first phase of the attack and blowing himself up. Once the explosion was heard, the four men began their assault, where they engaged 2 Kenyan police officers guarding the gate. The men then threw hand grenades at 3 unattended parked cars, setting phase 2 of the attack into motion. 2 explosions to create panic and confusion. The 4 men then entered the complex and split up into 2 groups as they made their way to the first office block and began shooting and throwing grenades inside. And at this point, everyone is trying to escape and call for help by any means necessary.
So what's wild about this, I guess, and what PubMedic shows, this is 2019, right? Not 1997. They're showing like people were tweeting about this. This is fucking wild to me.
Members of private security forces and armed individuals, along with some off-duty police officers, were some of the first to respond. At which time, an unknown person present at the complex picked up his phone and called his friend, Christian Craighead. He answered the phone and could hear the sound of gunfire coming from the background. The man requested for Craighead's assistance at the complex. He grabbed his gear and jumped in his truck, dodging in and out of traffic and arriving on scene only moments later. He had little to no intel on what was specifically taking place, but the sound of automatic gunfire was evident. Wearing a balaclava, body armor, and freaking Armani jeans. This dude's 007. And he's also got a Black Rifle Coffee Black Beer patch.
This fucking guy. With a Black Rifle Company logo patch.
Craighead armed himself with a Glock 17, a combat knife, and a suppressed Mako C8 carbine rifle. And without orders, relying only on his elite training and battle-proven instincts, the SAS operator went rogue and
fucking Giga Chad over here with his Armani jeans and kitted out.
mobilized himself. And just like that, Obi-Wan Nairobi was born.
Obi-Wan Nairobi. Was that his actual fucking nickname? This dude is seriously out of Task Force 141.
Craighead could be seen escorting dozens of civilians out of the complex and even carrying out the wounded. And with each pull, he turned around and went right back in and did it again. The locals were in awe of a masked foreigner who appeared to be single-handedly taking control of the situation wherever
What is this guy?
It wasn't long until reinforcements showed up. As police and other Kenyan forces responded to the scene, Kenyan soldiers and police established a perimeter around the complex. Craighead embedded with a group of the soldiers and moved through the complex to continue rescuing employees and guests who were still pinned down within. And footage from the event even shows him leaving those forces behind and taking matters into his own hands to directly engage the enemy.
This fucking guy.
While clearing buildings and sweeping the courtyards, Craighead located the terrorists and swiftly engaged the enemy, single-handedly killing 2 of them. Gunfire altogether had ceased, and authorities and Craighead alike began to clear the rest of the complex, as the actual number of attackers was unknown at this time. He assisted with coordinating logistics with local Kenyan authorities, went room to room searching for remaining attackers, and provided remaining civilians with a safe escort to the outside perimeter of the complex. While it had been thought that the threat had been neutralized, after a few hours, gunfire and explosions were again heard in the early hours on January 16th. As Kenyan police located the remaining 2 gunmen in a hotel room, and after engaging the men, the Kenyan police apprehended the wounded suspects. And by 11:48 p.m., the Kenyan government announced that the 14 Riverside complex had officially been secured. "20 Kenyan citizens, an American and a British South African man, died during the attack." The terror group Al-Shabaab issued a statement claiming the attack was coordinated with the assistance of Al-Qaeda as retaliation for the relocation of the U.S. Embassy in Israel. Christian Craighead was awarded a Conspicuous Gallantry Cross for ending the 19-hour siege, which is the second highest honor in the United Kingdom. His heroic actions saved hundreds of lives, and he retired from the SAS in 2020. He wrote a book about the event titled One Man In that is currently pending approval from the Ministry of Defense.
Nice. Fucking
Hey
awesome.
guys, if you enjoyed this video, be sure to hit that subscribe button. There's a lot more of these mini documentaries.
All right, we can do the roof Koreans.
Wednesday.
Scott, you have a Victoria Cross?
April 29th, 1992. Chaos erupts in the streets of Los
Okay, so if you don't know roof Koreans, 1992, the LA riots. Again, you Zoomers weren't even born at this point, for fuck's sake. I was born at this point, but I was too young to know what was happening. My earliest memory of a major news event was Desert Storm. But I barely remember rooftop Koreans. I barely remember Somalia. The next, I only recall Nixon's death and funeral, and then after that, it was the Oklahoma City bombing. Before that, it was Desert Storm, and that's it. 1992, this was after the Rodney King trial. The 4 officers were acquitted. A lot of people were pissed off about that. It escalated to wide-scale rioting in LA, and in particularly the Korean district or area of LA was particularly hit. And we're going to find out why there is a legend or a name associated with roof Korean.
Los Angeles, as tens of thousands of looters
I'm 37, by the way.
pillage the city. And with emergency services unavailable, business owners were left to fend for themselves. And out of all the stories told of the infamous 1992 LA riots, none have scratched the surface between myth and legend, like the story of a group of Korean immigrants taking arms on rooftops. This is that story.
I was not 51. Again, Popo Medic with the fucking sick beats of his videos. Shout out to Popo Medic. Sub to this motherfucker. Do it. Josh, I miss actually playing Cyberpunk. I want to play Cyberpunk again. I'm just waiting for the RTX 4090 to arrive at my doorstep.
Hi everyone, Donut here. The wait is over. I finally got around to making the roof Korean video after years of anticipation. Just kidding. Here's Popo Medic.
In April of 1992, 4 LAPD officers were tried following one of the most controversial excessive force incidents in American history. And after the Rodney King verdict was read, all 4 officers were acquitted, resulting in immediate protest.
Earlier, we had quite a scene where protesters did storm the doors of Parker Center.
The protest started out peaceful, but at approximately 4:15 p.m., a group of men approached the Payless Liquor in Delhi on Florence Avenue. The men walked into the liquor store, grabbed whatever the fuck they wanted, and walked out with no intention of paying. 2 of the men smashed the liquor store's front door, and another man struck the store owner's son with a beer bottle, rendering him unconscious. 911 was dialed.
So, again, this is post Rodney King, 1992, right? Again, we don't need to talk about what happened in 2020. So in 1992, there was a lot of situations going on. Now, do not get me fucking twisted. I'm not saying that the like burning of buildings is justified at all. I don't. Especially when it comes to people who had nothing to do with anything. But I also understand where the anger is coming from at the same time. I feel like you could actually you could see both sides of a situation, right? But maybe the alcohol is getting to me. But there's a reason for why people are just gonna see like, fucking let it burn. I don't give a fuck, because the institutions that exist here are against us. So fuck it. That doesn't excuse them torching a business that had nothing to do with what was going on. Right? That's a separate issue.
And 2 officers from the 77th Street Division of the LAPD responded, finding that the offenders had left upon arrival. And while making checks in the area for the offenders, a young man threw an object at their car. Approximately 24 officers, commanded by LAPD Lieutenant Michael Mullen, arrived and arrested the teenager. But the teenager put up a fight and resisted arrest. The teenager was a well-known minor in the community, further agitating a mass crowd of people who witnessed the arrest. The police formed a perimeter around the arresting officers as the crowd grew more hostile, leading to further altercations and arrests. And fearing the situation could potentially escalate to a life-threatening situation or the use of deadly force, Lieutenant Mullen ordered officers out of the area altogether. And by 6 p.m., the looting began on mass scale.
Rampaging protesters looted businesses in South Central Los Angeles, setting dozens of fires. One fireman has been shot.
The crowd began to turn physically violent, seriously injuring bystanders and other members within the crowd, absolutely polarizing the community and devastating business owners.
Yes.
That's right! That's not right! It's not right what y'all doing!
This, I do recall this. This became like a viral situation with this guy. Because again, his business was getting torched by rioters. again, what are you're going after the wrong person. If there was any legitimacy, you'd be torching the cop cars, you'd be torching police stations, you'd be torching institutions like that. You wouldn't be torturing a local business
much rejoicing.
owned by somebody who lives in the very community that you live in.
I came from the ghetto too. Same as all of you did.
The growing number of rioters in the streets began attacking civilians, throwing debris at cars, pulling people from their vehicles, smashing shop windows, and setting them on fire. The chaos had sent shockwaves into the living rooms of millions of Americans across the nation.
Leave me alone, Mandy.
Chinese immigrant by the name of Choi Si Choi and a trucker named Reginald Denny, who was delivering.
This is the big one that I do remember, and I do remember seeing, is this trucker who was basically pulled out of his car and beaten to within an inch of his life on live television.
Gravel for the construction of low-income housing were both horrifically attacked during live coverage of the riots. At approximately 7:15 p.m., as reports of vandalism, looting, and physical attacks continued to come in, Lieutenant Mullen elected to take the information but not respond. Mullen was later relieved by a captain, ordering officers only to assess the Florence and Normandy area. And at 12:15 a.m., Mayor Bradley signed an order for a dusk to dawn curfew, as well as declaring a state of emergency for the city of Los Angeles.
Damn, Chuck.
And on the following day, by mid-morning, violence appeared widespread, as extensive looting and arson was witnessed across Los Angeles County. The rioting moved from south-central Los Angeles, going north through central Los Angeles, decimating the neighborhoods as far as Westlake to Fairfax, before reaching Hollywood. The looting and fires engulfed Hollywood Boulevard, and simultaneously rioting moved west into neighboring independent cities of Compton, Carson, and Long Beach. You might even remember Long Beach native Bradley Noel singing about it on Sublime's self-titled album.
First spot we hit it was my liquor store.
R.I.P. Bradley Noel, fucking legend. From Olympic
Fucking legend.
Street to 120th Street laid the forefront of many small family-owned local businesses, primarily owned by first-generation Korean immigrants.
So, yeah, the rioting eventually moved itself into Koreatown, and here we go.
Many of whom escaped from North Korea into South Korea before immigrating to the United States. Many of whom were formerly voluntold soldiers who knew how to fight.
Voluntold.
And the fight came to Koreatown rather swiftly, as rioters moved up north from Florence and Normandy with a newfound thirst for looting.
And I want to emphasize that there was already a lot of interracial animosity between these two communities before the rioting. But I think Popo Medic mentions that too.
At 11:30 a.m., one employee of a local gun store, David Jew, was working behind the counter when the shop phone rang. It was a phone call from his employer, Richard Park, who owned another store a few doors down. Richard informed David that he was at the nearby shop and in the middle of a gunfight. David locked up the gun store, ran across the parking lot, armed with a Beretta. When he arrived, he heard gunshots, at which point looters from across the street made their way to the gun shop plaza and opened fire on Richard and David. But when the two men fired back, the assailants fled the area immediately. Word quickly spread throughout Koreatown that this method had worked, in not only protecting Richard's property, but his life. Korean business owners who caught word of this began to phone in a Los Angeles-based radio station called Radio Korea, pleading to the radio station's audience for an armed response to help protect their property.
Everybody parked in the street, took some everything, liquor, beer.
When you got here, you said people were still inside the store. What did you do?
Still inside. I shut 8 times, everybody moved.
A merchant guarding his property. You got anybody out there or just a shop?
Rick Romero out here. All of the merchants.
So, this is what a well-regulated militia looks like.
Here are not going to wait for the National Guard or police or anybody else. You talked about
guerrilla warfare, and it's right here, right on the premises here. Just about every one of the individuals in this.
Radio Korea quickly became dubbed Koreatown's makeshift command center, warning listeners of the whereabouts of incoming looters, and offered itself as a 911 system, allowing shop owners to call out for help over the air. After the realization sank in, there would be no response from police, fire, or EMS.
Basically, yes, because the reason why is because they are fucking overwhelmed at this point. They have no manpower. And my understanding of the situation is that apparently there was also a shooting that happened before the Rodney King incident involving a Korean woman or a black woman in a Korean store. I can't recall what the situation was at the time, but there was bad blood between these two communities before the LA riots, and the Rodney King thing, the riots themselves, was basically the lit fuse, which just goes to show you that this whole bullshit that only a certain group of people can be racist is full of shit. But I digress.
On the premises here, just about every one of the individuals in this.
Radio Korea quickly became dubbed Koreatown's makeshift command center, warning listeners of the whereabouts of incoming looters, and offered itself as a 911 system, allowing shop owners to call out for help over the air. After the realization sank in, there would be no response from police, fire, or EMS, already stretched too thin, responding to thousands of ongoing emergencies.
한수 옷가게라고 있습니까? 한일도 옷가게 거기는 남자 옷이에요. 남자 옷가게. 네, 거기 탔어요? 네, 거기 지금 불타고 있어요.
We need additional guard in here.
We have no police support whatsoever. People are driving by shooting at us, and we have to do something about it.
A local resident by the name of Ina Cho and president of the Korean Veterans Association in 1992 was listening to the broadcast and decided to call in a little broadcast of his own, requesting all Korean Marine Corps veterans to respond to the area. Soon after, a group of around 15 Korean Marine Corps veterans,
fucking Korean War vets. This was 1992. Korean War ended in what, like 1953, 54? So these dudes were in their, 50s, 60s?
arrived, equipped.
The National Guard did not come into LA until what? Somebody could correct me, but maybe 2-3 days after the riot started.
With rifles and rendezvoused with Cho. The men responded to a large electronics warehouse, Kim's TV, where Radio Korea was broadcasting that a mob of looters were attempting to break in. The warehouse had an iron door, which the mob was beating and ramming with a truck. When the mob finally took down the door, Cho attempted to stop the looters who were sprinting inside when 2 vehicles with a combined occupation of 10 people got out of their cars and opened fire on Cho, hitting him 1 time. Richard Kim, whose parents owned the electronics store, armed himself with a semi-automatic rifle. As the warehouse was under fire, his mother suffered a gunshot wound while trying to shield his father. And as more Koreans became injured, more and more Koreans took up arms, taking positions on rooftops for maximum tactical advantage. Not only did they have the high ground and could see everything from the roof, but parapets made for the perfect cover from incoming fire.
Paul Berry says $2 Korean war vets or war vets that are Korean. Yes. The answer is yes. That they're Korean and they're also veterans of the Korean War.
And these firefights were televised.
More familiar with weaponry than I am. He says it looks to be a 9mm Uzi.
Where Korean shopkeepers could be seen armed with M1 carbines, Ruger Mini-14s, pump-action shotguns, handguns, and Daewoo K1A1s. Like, look at this dude's loadout. He's
the iconic photo of the rooftop Korean.
He had a red polo t-shirt and a Daewoo K1A1. I mean, come on. One of the most iconic photographs of roof Koreans happened at a small grocery store called California Market. The owner fortified his store with 20 well-armed employees and volunteers, all of whom were wearing white headbands. They were often shooting blanks or discharging warning shots into the air, which is dumb. Gotta wonder where those went, you know? But their methods worked, as looters scattered, fleeing the area as quickly as they could. On May 3rd, after 4 days of exchanging gunfire with armed looters, the rooftop Koreans successfully forced every single wave of remaining mobs out of Koreatown, saving countless lives and livelihoods in which the Korean American identity was born. And on that same day, over 1,100 Marines and 6,500 National Guard troops patrolled the streets of Los Angeles, putting an end to the chaos.
No, and you're right, Deacon. The vast majority of them just simply fired into the air, which apparently was an effective deterrent. The problem is you're firing into the air. What comes up must come down.
If it wasn't for a few brave men who stood up against their opposers, Koreatown would have been unsalvageable. The nearly week-long rioting killed more than 60 people, injuring more than 2,300, and caused approximately $1 billion in damage, half of which was sustained by Korean-owned businesses.
So, $500 million of property damage was in Koreatown.
Korean Americans have come to refer to the 1992 uprising as Saigu, which translates to April 29th, a day Koreans will never forget. Hey guys, if you enjoyed this video, be sure to hit that subscribe button. There's a lot more of these videos in the works.
Man, fucking love this. All right, we got one last one. I can't recall if I actually showcased this on the stream or if I showed it to my friend.
Monday, August.
But this is the last one I'll show before calling it a night. But it involves an Army Ranger. Excuse me. Army Rangers pulling off a bank robbery.
7th, 2006, 5:15 p.m. The most sophisticated bank robbery in Washington state history. A four-man team led by two special operators swept a Bank of America in Tacoma, Washington. One FBI agent would later describe the event as executed with elite military-style precision and planning. They carried enough weaponry, according to prosecutors, to create a bloodbath in the streets of Tacoma.
I mean, I would have wanted to become a JAG. I actually did at one point want to become a JAG. Army Ranger bank heist of 2006. Well, Archangel, if I have to get rid of the beard, then forget it.
Luke Elliott Summer was born on June 6, 1986 in Peachland, British Columbia. He later
1986. So in 2006, he was my brother's age, which would put him at, I was 15 in 2000, 21 in 2006. This motherfucker was 20 in 2006.
Later joined the Army on June 6, 2003. After completing one-station unit training, Summer attended and completed airborne school at Fort Benning before attending the infamous Ranger Indoctrination Program, now known as RASP. Summer was sent to the 2nd Battalion's 75th Ranger Regiment. Summer was at the unit for less than 3 weeks before he was shipped to Baghdad, Iraq, where he remained until September 2004. After returning from Iraq, Summer conducted Ranger convalescent skill training, which includes hot wiring vehicles, operating heavy machines, and basic EMT courses. After spending 6 months stateside, Summer was again deployed, but this time to Afghanistan. When Summer returned from Afghanistan in September 2005, he was sent to Ranger School, a 61-day leadership program where young soldiers are pushed to their absolute limits.
Get up there! Hurry up! Ranger, what is wrong with you?
Summer spent nearly 7 months completing the highly prestigious military leadership school, and although he restarted the school twice, Summer managed to complete the school on April 7th, 2006, earning his tab. While waiting for his next deployment, Summer and his Ranger buddies in Barracks Building 3475 spun fantasies late into the night about applying their training to American civilian settings. Summer kept pushing these ideas further and further until the next thing anyone knew, he and a few other Rangers were pulling reconnaissance on the nearby Chips Casino. Summer began sharing this fantasy with friends back in Canada, such as 20-year-old Tigra Robertson, a member of the Canadian Military Reserves, and 18-year-old Nathan Dunmall, a civilian.
Oh boy.
Summer spelled out the plan to Robertson via text message. In a July 30th, 2006 exchange, Summer wrote, "We're going to hit this casino, and we have a solid plan. We have a driver, 2 Rangers, and you 2. So I hope you're ready to fucking rock and roll." Robertson replied, "Fuck yeah." Summer replied, "Chance it might go North Hollywood, so I really hope you're in the mood."
Chance it might go North Hollywood, so I really hope you're in the mood. What did we just watch 20 minutes ago, ladies and gentlemen? Fuck!
On August 3rd, 2006, Alex Blum drove Summer to the Bank of America in Tacoma, Washington, for what the 2 Rangers referred to as close tactical recon. Summer scoped his target where he had a checking account. He surveyed the room, and then he spotted it, a 2-foot space between the top of the bandit barrier and the ceiling. Back at the barracks, he mapped out distances to and from the bank using Google Earth, and spent hours studying news articles about robberies, learning from the mistakes of less careful robbers. By Sunday, August 6th, Robertson and Dunmall had arrived by bus from Canada. Summer led them along with Ranger Chad Palmer to Noble Hill, the 400-foot mountain that rises behind the Ranger barracks. He laid out sandbags and stuck sticks into the dirt to mark the bank's floor plan and the building's exact distance from the alley where Blum, who'd agreed to be the driver, would park his car. Then the 4 men ran the distance in full gear, armor, and weapons. They rehearsed every step over and over again.
They actually set up a building plan in their base or barracks of the bank and ran the whole scenario.
Who would stand where and for how long? Summer's squad was ready for the mission. On the early evening of August 7th, Robertson handed out the weapons. The 2 AK-47s for Palmer and Dunmall, a 9mm Glock pistol with a red dot for Summer, and a spring-filled 9mm for himself. Dunmall tossed a bag with several hundred rounds of ammunition over his shoulder. They grabbed frag grenades, flashbangs, suited up in body armor, and piled in Alex Blum's vehicle. With Alex Blum behind the wheel, the 4 men arrived at Bank of America branch in South Tacoma at 5:14 p.m.
No spoilers, Omega.
They entered the bank at 5:15 and the robbery began. Palmer and Dunmall with automatic weapons covered the bank's entrance, while the other 2 with handguns moved swiftly to confront the tellers. As the robbery commenced, the countdown began. One of the door guards began to call out the elapsed time like something straight out of a fucking movie.
You mean, or Payday 2?
Summer vaulted over the teller counter and barged behind the bandit barrier into the cages, ordering the tellers to only hand over stacks of bandit 20s, 50s, and $100 bills, and gave further orders not to include any bait money with
no bait money and no sequentials,
pre-recorded serial numbers or die packs. His assistant collected the money from the teller station and took $20,000 from a money cart inside the vault. At the 2-minute mark, the timekeeper shouted, "Let's go." The 4 men exited the bank with $54,000.
That's it! That's her entire take. Compare that to the North Hollywood shootout and what their take was before they pulled off the North Hollywood shootout. They had over $1 million before they engaged in the North Hollywood shootout. These guys only took in $54 fucking K.
$11. They slipped through the back door, successfully robbing the bank in just 2 minutes and 21 seconds. But things almost took a major shit. As the men ran down a side street into an alley, the getaway car wasn't there. The driver had panicked and started driving back to the base. He realized he was going the opposite direction of the
So the driver panicked and was trying to get away and then made a U-turn.
He made a U-turn. With rifles and duffel bags in hand, the men saw him make the U-turn and assumed he must have been driving down the street to turn around to catch up to his fellow bank robbers. The three men ran to the car and made their getaway. The driver, Alex Blum, played it off like he was in fact making a U-turn and not fleeing the crime scene. Blum dropped Palmer, Robertson, and Dunmall off at a movie theater where they laid low in a darkened theater, eating popcorn, watching a horror movie. Much tactics, many operator. Blum and Summer then headed back to the base, ditched their gear in Summer's room. Blum flew home to Denver the next morning. Summer, Robertson, and Dunmall busted back to Canada. FBI Special Agent Monte Shade arrived at 5813 South Tacoma Way a little after 5:30 p.m., only 15 minutes after the robbery occurred.
So, FBI arrived 15 minutes after the robbery itself. That's pretty fucking awesome time there.
The parking lot was already full of Tacoma's White Crown Victoria police cars. In his 8 years with the FBI's Pierce County Violent Crimes Task Force, Shade had investigated nearly 400 bank robberies. Most were easy to solve, the majority being crackheads trying to get their fix and get some crack. Right away, Shade knew this one was different. 4 young men, maybe aged 19 to 21, 2 with rifles, 2 with pistols. Then Shade, who'd also spent 8 years on a SWAT team, reviewed the security footage and noticed these guys were definitely using close quarter battle tactics.
And that's what happens. That's what happens when you have an FBI agent with experience who's able to discern things like that. Member of SWAT who's able to see that these guys are engaging in a way that's not inducive of some schlub. And that's where you fuck up.
He noticed how the 2 men holding the door did a great job in their sector, which is their AOR, or Area of Responsibility. Special Agent Shade also took note of how one robber went flying onto the counter, grabbing the top of the 8-foot bandit barrier with one hand and vaulting himself over to the other side, a move that requires some form of athleticism. At the bank, a witness came forward who took down the license plate of the vehicle.
Oh, by the way, they didn't hide their own fucking license plate!
These idiots left the front license plate on Blum's vehicle. After running the plate, the RO came back to a Norm and Alex Blum of Greenwood Village in Denver. Reviewing the close quarter battle tactics on the security video, Special Agent Shade suspected a military connection. He drove to Fort Lewis the next day and asked the Provost Marshal if a Norm or Alex Blum was a soldier there. The inquiry brought him to the barracks building 3475. Most of the Rangers had cleared out for a 2-week leave, but Shade pressed a few stragglers who admitted seeing Blum, Palmer, and Summer with a large amount of cash the night before. One by one, the robbers got picked up by authorities. The FBI nabbed Alex Blum in Denver, Chad Palmer in full dress uniform, as him and his family were leaving their house in Chesapeake for family pictures when a SWAT team swarmed in. Nathan Dunmall was arrested in British Columbia, Robertson surrendered at the Canadian-American border, and as for Summer in Peachland, he was quoted as saying, "My fucking dad turned me in." On December 15th, 2008, Summer was sentenced to 24 years in prison and 5 years of supervised release for conspiracy to commit armed bank robbery, brandishing a firearm during and in relation to a violent crime, and possession of an unregistered destructive device, aka a fucking grenade. Summer was also sentenced to an additional 20 years in prison on March 8th, 2010.
Oh, by the way, this happened
for
too.
assaulting a co-defendant and plotting to kill a federal prosecutor.
Well done. Well done.
All of the other defendants in the case entered guilty pleas in 2006. Chad Palmer was sentenced to 11 years in prison. Tigra Robertson was sentenced to 12.5 years in prison. Alex Blum was sentenced on March 6, 2009 for a total of 16 months after he Tekashi 6ix9'd everyone else involved.
He ratted them out.
Nathan Dunmall was sentenced to 10 years in prison. Scott Byrne, who assisted in planning the heist, was sentenced to 8 months in prison. Thank fucking God the situation didn't turn into a firefight with law enforcement. Summer claims he did the robbery to bring attention to war crimes and other allegations involving Task Force 626. But
bullshit.
It was later revealed that the money stolen was intended to create a motorcycle gang that would rival the motorcycle gangs controlling crime in fucking Canada. It's fucking stupid. This guy's an idiot. Thank you guys for watching this video.
Yeah, that guy is a fucking idiot.
If you like my historical crime,
that is such a fucking horse shit, bullshit ass excuse. What a fucking moron. Anyway, that's the end of that.
Be sure to check out my Norco shootout.
So the way I see this is that these guys, they had the skill and the tactics and the wherewithal to pull off the actual heist, right? But they accounted for nothing else. The aftermath, anything. Like the way I see it is that if they had an experienced bank robber, like somebody with like legit experience at the helm, and that they were nothing but the point man, then they would have actually pulled off something, because the guy with the experience would have said, "Don't put your goddamn license plate on your fucking getaway car." Oh, Dios mío. All right, I'm done. I gotta go eat my cold pizza. It's probably cold by now, but it's okay. I'm hungry anyway. I'll eat it. But thank you guys for watching. Hope you guys have a good weekend, and I'll check you guys later. I might be on tomorrow. Excuse me, tomorrow. And yeah, that's about it. Oh, excuse me. Take care of yourselves. Be well. And I'll see you next time. I got the goddamn hiccups. Bleh. Oh no.